Mr. Wright, I think we're ready to begin.
Good morning, Commissioner. Before we start with our witnesses this morning, can I introduce the legal representation? Attending on behalf of the Attorney General and the elected ministers remotely is the Solicitor General Joanne Williams-Roberts, and attending on behalf of a number of members of the House of Assembly, Mr. Richard Rowe. Our witnesses, our scheduled witness this morning is Mr. Joseph Abbott, but we have an additional witness, and that's Mr. Ian Penn, who's they're effectively going to give evidence together.
Yes.
Gentlemen, can I thank you for coming back to give evidence? I suppose a special thanks to Mr. Penn, because you were volunteered by Mr. Smith-Abbott rather than being requested by the Commission. But you've both made affirmations when you first came to give evidence, and there's no need to take the affirmation again. You're still bound by that. But the way that I propose to deal with matters this morning is that I'll put my questions towards Mr. Smith-Abbott, but if you feel, Mr. Smith-Abbott, that it's a question that's better directed towards Mr. Penn, if you defer to him. And similarly, Mr. Penn, you could defer to Mr. Smith-Abbott, or if there are matters where you can add additional detail, please feel free to do so. There is a bundle on the desk in front of you, and we might need to go look at some of the documents as we go through. My last request is, can you both just remember to keep your voices up? The microphones that you have in front of you won't amplify, they'll just record. So if anything, I'd suggest that you pull them as close to yourselves as you can. The topic on which we are asking questions today is in relation to the grant of belongership. Now, on the 29th of July of this year, the Commission sent a letter to the Honourable Vincent Wheatley asking for an affidavit on the issue. And that response was provided by you, Mr. Smith-Abbott. Now, given that you were appointed as Honourable Wheatley's Permanent Secretary in May 2021, why was it thought that you were better qualified than the Minister to make the affidavit on such an important topic?
Good morning, or good day, everyone. And Commissioner, I would also like to thank you very much for allowing the Chief Immigration Officer to be a part of the evidence given this morning. It was important, perhaps, for myself to coordinate the response, since there are a number of technical matters related to belongership and the grant of belongership over time, which coordinating with the Immigration Department, it was deemed to be important and suitable for that response to be put together, and for at least technical matters that were addressed in the various requests to be considered at that time and bundled, so to speak, and responded to.
Now, you made on this topic, on behalf of the Minister, 2 affidavits. Can I ask you just to take up the first bundle, please? Just turn to page 364. That's the first page of, in fact, your 4th affidavit, Mr. Smith-Abbott, to the Commission. If we turn through to page 366, you confirm that it is dated the 26th of August 2021 and carries your signature.
Yes.
The second affidavit that you've made on the topic of belongership we find in bundle 2. Page 1338. What I think is
we'll see.
Yes. You're right, 1328.
I'm sorry,
1328.
It's in bundle 2.
This is now, in fact, the seventh affidavit that you provided, Mr. Smith-Abbott, to the Commission, but it's the second one on the topic of belongership. And if you turn through to page 1350, again, could you confirm that's dated the 10th of September 2021 and carries your signature?
Yes, it does.
And are you content that these two affidavits should stand as part of your evidence before the Commissioner?
Yes, I am.
Now, from your earlier answer, indeed from the presence of Mr. Penn here today, the affidavit itself is the work of a team of public officers. Would that be a fair way of putting it?
That is very correct.
And was your role was to coordinate that process? Is that right?
Yes, it was.
Well, can I start off by thanking you and your colleagues for your efforts in putting together the affidavits on belongership. As the Commissioner has recognised, public officers have often had to shoulder the burdens of requests from the Commission, even when they are directed to ministers, and have had to do that with sometimes limited support. And we are grateful for the efforts that you and your team have put in.
Thank you, sir.
I just need to clarify one detail with you in relation to, we can take it with the second affidavit first. You've put in at paragraph 5, which is at page 1329. What you say is, at the outset, I should further say that in this affidavit where I mention the document, I do not waive any privilege asserted in respect of it unless I do so expressly. Are you able to clarify any further at this point in time whether there is any document that you do assert privilege over?
Given the fact that belongership discloses, the process of belongership discloses quite a considerable amount of biographical personal information about individuals, it was deemed necessary in this particular case to exercise some degree of right over personal data, which may also include potentially convictions and other types of events that, in other words, may not be in the best interest, public interest, to disclose at this time.
That's to do with personal data, and certainly I understand that. And it's important as we go through any evidence today that none of us refer to personal data, including names. I understand that. But what about privilege, which is a different matter?
Privilege otherwise would be, I mean, the bundle itself has no information that otherwise we will exercise any privilege over, because so it's process driven. It's purely personal data. Correct. Which becomes the subject of a privilege in this case. I understand it to be. It's confidential and should be referred to. Yes. Correct.
But what may set your mind at ease, Mr. Smith-Abbott, is that firstly, the Commissioner has throughout made clear that all disclosure is to him in the first place alone and is confidential. And secondly, the position that was taken by the Attorney General in respect to documents with which you are concerned today, and it's a matter on which the Commissioner has not ruled, is that the Attorney General was not going to disclose all material. And therefore, I suspect that much of the material with which you are concerned, which is individual biographical data, has in fact not been provided to the Commission. So that may assist us. In relation to, is the position the same then in relation to the exhibits that you appended to your first affidavit, the fourth one that we've just looked at?
Correct.
Can I begin then just by asking you both to confirm that the key aspects of the legislative framework. The first part is, and we don't need to turn up these the pages, but I'll give the Commissioner the references. But the starting point is the Constitution, isn't it?
That is correct.
And specifically that section 2.2 sets out what the definition of a belonger is.
That is correct.
But then in terms of the piece of legislation that is the overarching piece of legislation, we have to look to the Immigration and Passport Act of 2013.
That is correct.
And Commissioner, in this bundle, you will find the Constitution at page 1366 in the second bundle, with section 2.2 appearing at 1370.
Yes, thank you.
In terms of the Act itself, the 2013 Act, we'll find that at 1425. That's where it starts, but the key provision is at 1438, and that's section 16. Is that right?
That is correct.
And if we look at section 16, and I'll ask you to give the Commissioner some more detail about how it operates in due course. But that's headed certificates that a person belongs to the territory, and that will set out essentially the basis on which someone can apply for a certificate of belongship.
Yes, indeed.
Section 17 is headed validity of certificate issued under section 16. And then section 18 deals with a different status, and that is resident status. Is that right?
That is correct.
And resident status can be revoked by the Cabinet under section 19. Is that right?
That is correct.
Which can include, if we look at page 1441, if the person has in any country been sentenced to imprisonment for a criminal offence for a term of 1 year or more.
Under subsection B.
Subsection B, yes. So that deals with resident, but can you help me with this? If you turn back to section 3, which is at page 1432, please. That's headed persons who are deemed to belong to the territory. And at section 3, and you've set this out in the affidavit, Mr. Smith-Abbott, it says, for the purpose of this act, a person shall be deemed to belong to the territory if that person so qualifies under section 2.2 of the Virgin Islands Constitution Order. And then it gives, under subsection 3.2, that subject to subsection 3, the governor may at any time by order declare any person deemed to belong to the territory by virtue only of a certificate of naturalization to be no longer deemed to belong to the territory on the grounds that, and then there are various grounds set out, which include at C, has within 5 years of the grant of such certificate been sentenced to imprisonment in any country for a criminal offence for a term of 1 year or more, or D, has obtained such a certificate by means of fraud, false representation, or concealment of any material fact. Just to break that down a little, firstly, is it right that when the Act refers to a certificate of naturalization, it's referring to a certificate that you can obtain under section 16?
Okay, so at this time, I would like to invite Mr. Penn, if possible, to provide the answers to these questions.
Certainly.
Thank you.
And Mr. Penn, I think we should introduce the transfer. Of course, you're Chief Immigration Officer, so
Yes.
You have a certain level of expertise.
Yes,
Do you want me to put the question again? Or,
please.
where subsection 3.2 refers to a certificate of naturalization, is that a certificate that you would be granted under section 16?
Naturalization? No, certificate of naturalization is granted through the Passport and Visa Office. And a certificate of naturalization can come where someone has attained residence, and 1 year after residence, then they can apply for a certificate of naturalization.
So is there any provision by which once an individual has been granted belongership, that grant can be revoked?
Well, the law states that under section 17(2) C, it says, has within 5 years of the grant of such certificate has been sentenced to imprisonment in any country for criminal offense for a term of 1 year or more, or D, has obtained such certificate by means of fraud, false representation, or concealment of any material fact.
And thank you for drawing our attention to that. So once you have a certificate under section 16, the cabinet can revoke it if, having been granted that, you engage in any of the activities set out there, which can include being sentenced to criminal offence.
Yes.
See. Thank you. May need to come back to that as we get deeper into section 16, but I just want to flag up the other two significant pieces of legislation that we will need to look at today. And that is the two Immigration and Passport Amendment Acts passed in 2019. So that is, we'll find the first one at 1493 in the bundle, which was Immigration and Passport Amendment Act 2019, number 5 of 2019. And that made amendments to section 16 and then was followed, and that was, I think, was assented on the, or gazetted on the 18th of June 2019. And then Immigration and Passport Amendment Act number 2 of 2019, gazetted on the 2nd of September, also came into force. Now, those two acts make amendments to section 16, and in effect, keeping it simple, because it is something I'd like some detail on, but it introduced what has been called a fast track scheme to get belongership status. Is that right?
Yes, correct. Just a point of note as well. Well, yes, section 16, yeah, these would belong as status, yes.
Yes. I will ask you, I think, to just, as we go through, probably give the Commissioner a lot more detail about how it works as we go through. But if we start off with belonger status, so our starting point, as we've said, is that someone is deemed to belong if they fall within section 2.2 of the Constitution Order of 2007. And it's right, isn't it, that belonger status will bring certain privileges, which include voting rights and the right to remain free from immigration control.
Yes.
Now, if we turn to, and I know the bundle is with you at the moment, Mr. Penn, and it might be sensible to keep it there, but if you turn to page 1329 in that bundle.
This is bundle 2? This is bundle
yes.
2.
At 1329, we find paragraph 8, and the affidavit sets out section 2.2. And if you go over to the next page at 8.5, it deals with the different ways in which a person can obtain belonger status under the Constitution. And could you just set out for the Commissioner the different sort of elements of belonger status that are available under the Constitution?
Right. So under the Constitution, 2A states is a person belongs to the Virgin Islands if that person is born in the Virgin Islands and at the time of the birth his or her father or mother is or was a British Overseas Territory citizen by virtue of birth, registration or naturalization in the Virgin Islands, or by virtue of descent from a father or mother who was born in the Virgin Islands. And then under 2, it says settled in the Virgin Islands for the purpose. Settled means ordinarily resident in the Virgin Islands without being subject under the law in force in the Virgin Islands to any restriction on the period for which he or she may remain. Does not include persons or contract with the government of the Virgin Islands or any statutory body or crown corporation. B is born in the Virgin Islands of a father or mother who belongs to the Virgin Islands by birth or descent. So B goes back to A, where a person is born of a father or mother who belongs to the Virgin Islands by birth or by descent. C is a child adopted in the Virgin Islands by a person who belongs to the Virgin Islands by birth or descent. So that is pretty straightforward. D is born outside of the Virgin Islands of a father or mother who is a British Overseas Territory citizen by virtue of birth in the Virgin Islands. This means that someone is born outside of the territory, outside of the BVI, whether in the US or another country, but however their parents, their mother or father is from the territory, okay? E is a British Overseas Territory citizen by virtue of registration in the Virgin Islands. That means British Overseas Territory citizen. We have Caymans, Anguilla, those places, Bermuda, which are overseas citizens, and they can register here in the territory, here in this territory.
Could I just ask you to just keep your voice up a little bit, please, Mr. Penn?
Oh, sorry. F is a person to whom a certificate has been granted under Section 16 of the Immigration and Passport Act, 1977. And that of the Virgin Islands, and that goes to Section 16 of the Immigration and Passport Act that we are discussing here today. G is a spouse of a person who belongs to the Virgin Islands and has been granted a certificate under Section 16 of the Act. Again, Section 16 of the Immigration Act comes into play, where a spouse would marry someone who belongs to the Virgin Islands. And H was immediately before the commencement of this constitution deemed to belong to the Virgin Islands by virtue of the Virgin Islands Constitutional Order 1976A.
So to distill that answer down, and to summarize it, the position is that under the Constitution, a person could acquire belonger status either by birth or adoption.
Yes.
Or by virtue of having acquired British Overseas Territories citizenship.
Exactly.
The third way is by grant under Section 16 of the Act that we've been looking at. And then there's also then, as you said, Section 2(2)H being deemed to belong under the 1976 Constitution Order.
Yes, sir.
So turning to section 16, and if we look at paragraph 9.2 in the affidavit, which you'll find at page 1331. What has been helpfully set out in the affidavit is section 16 as it is in force today, and that sets out the different ways in which someone can obtain a grant of belongership under section 16. We can cross-refer that to paragraph 11.1 of the affidavit. And can you confirm this, Mr. Penn, that in summary, the different ways in which someone can get a grant of belongership under section 16 are as follows. Firstly, belongership, they can be a belonger by tenure, and that's based on the length of time residing in the territory. And that is under section 16, 1 and 3, that they have been ordinarily resident for a period not less than 10 years. The second way in which you can become a belonger by tenure is on what's set out in the affidavit or described in the affidavit as an exceptional basis under subsection 16(1) and 4, and that is where you have been ordinarily resident for a period of not less than 7 years. The third way, which we find at 16(5), is that in the exceptional circumstances of any case where Cabinet considers it fit to do so, it may, in its own discretion and without the need for an application, grant a certificate of belongership to someone who, in Cabinet's opinion, has made a significant and consistent contribution to the economic and social development of the territory over a period of at least 50 years. And then the fourth one is belongership by marriage. And then the belonger and the spouse must have been living together as husband and wife for at least 5 years. And then the last, which is a relatively new provision, is belongership by fourth generation descent. Is that an accurate summary of the different bases on which under section 16 someone could get a grant of belongership?
Yes, that is correct.
Now, leaving policy aside, but taking the grant of tenure first, and you might want to just look at paragraph 10 on page 1332. Again, perhaps without going into the detail of the Act, but someone who seeks to be a belonger by tenure, and that's under the not less than 10 years requirement, what are the criteria or the requirements under the Act for someone to obtain that status?
Going back to section 16, it clearly states the criteria there.
Sorry, your voice has dropped again.
Oh, sorry. Going back to section 16, it clearly states the criteria under section 3, where such person is of good character, is not less than 18 years of age, has been ordinary resident in the territory for a period of not less than 10 years immediately prior to his or her application, has held a certificate of residence granted under section 18 for the period of not less than 12 months immediately preceding the date of the application, and E, has in his or her application restated his or her intention of making the territory his or her permanent home and has satisfied the board that it is his or her intention to do so.
So good character, ordinarily resident for not less than 10 years, has to have held a certificate of residence for a period of not less than 12 months, and then must show an intent to make the BVI a permanent home.
Yes.
Now, you can get, as we've explained, belongership by tenure on an exceptional basis, and that's 16.4. But that's for Cabinet to decide after consultation with the Immigration Board, is that right?
Exactly.
And that can be, and again, the requirements are that the person who makes that application must be of good character, must be ordinarily resident in the territory, been so ordinarily resident for a period of not less than 7 years immediately prior to the application.
Yes.
Does it follow then, Mr. Penn, that that person does not have to be not less than 18 years old?
Well, as the section says, in exceptional circumstances, right? So exceptional circumstances could mean a lot of different things. Okay, it could mean less than 18 years. It could mean that the period of 7 years could be immediate. So it doesn't mean that it has to be a drawn out process, and therefore the age factor in this piece of legislation under Section 4 could mean that the age difference could be under 18 years.
Can I just set out what I think it means, and you can perhaps then confirm, Mr. Penn. There are 5 conditions under subsection 3 for, as it were, 10 years ordinary residence tenure. Subsection 4 provides that there are different conditions. One is good character. One is ordinary residence for 7 years. And a third condition is there has to be exceptional circumstances. So it seems to me that there is no requirement, no condition under subsection 4 that you have to be over 18, but there have to be exceptional circumstances.
Yes, exactly.
Yes. Because I think you have to look at it that way, because being under 18 is not in itself an exceptional circumstance, but it's not a condition of falling within subsection 4.
Right. Right.
Yes. Yes. Thank you, Mr. Rowe.
We looked briefly at the 2 provisions in 2019 that amended Section 16. It's right, isn't it, that those were time limited in terms of the changes they made?
Yes.
And I understand that the change was or the period in which the provisions were in effect was from the 3rd of June 2019, initially to the 1st of October 2019, but then it was extended, I think, to the 1st of February 2020. Is that right?
Yes.
Whether it's Mr. Smith-Abbott or yourself, but why were those changes introduced?
Is that what you? Yes, please.
Those changes were introduced at that point in time because there was the government of the day decided that they wanted to do a fast track, and to facilitate that fast track, then those amendments, were made at that point in time.
The temporary changes, as I understand it, Mr. Penn, were twofold. Again, correct me if I'm wrong, because and this is not a criticism, but they're fairly labyrinthine. But firstly, introduced a fast track, and secondly, introduced, I think, great-grandchildren provisions.
Yes.
The relationships are not straightforward. I think they're sort of great-grandchildren provisions. Both of those provisions.
Four generations.
Four generations, exactly.
Yes.
Both of those provisions, fast track and the fourth generation provisions, both were temporary.
I think the fourth generation.
No, the fast track was temporary.
The fast track was temporary. Fourth generation, which I think was new paragraph 5A, is permanent.
Yes.
Commissioner, if I may, just for sake of clarity, right? Because we are referring to fast track without defining what in law it actually means.
No, I mean, we'll come on to that. I mean,
I understand.
I'm using fast track only as a shorthand for whatever the provisions say.
Correct, but the fast track element of this was the fact that you have the period of ordinary residence being what is stated in the Act, and then that would lead to residence, and then from residence you have a 12-month period that will qualify that individual to become a belonger, at least to be considered a belonger. So that 12-month period was in essence shortened so that you would have a simultaneous, and Mr. Penn can correct me if I'm wrong, a simultaneous consideration of both residence and belongership. So that becomes the functional, practical need to address a significant backlog of individuals. So I think that we are employing the term fast track, and it's important to at least understand the context and understand what it actually means in the provisions that we're going through, so that individuals will be clear and the commission will be clear as to exactly what the material impact of that amendment, which was time bound. And the reason why it had to be time bound is because you would not want to permanently waive that 12-month period between the grant of residence to the grant of belongership, or at least a consideration, I should say, not the grant, but the consideration between residence and belongership.
I suspect Mr. Rao will have some questions about this. But
correct, but at least at this particular time, as we are starting to
look at it.
Correct, yes.
Perfectly fair, Mr. Smith-Abbott. As you said, and as I'm sure that we'll have some questions that go deeper into this, but ordinarily it's a two-stage process.
That is correct.
Residency and belongership. To become a resident and then to become a belonger, there is usually a process. It's not a right.
Correct.
There is a process which has to be gone through, and under the fast track, what's called the fast track system, those were effectively merged.
That's correct.
So that there was only one consideration of both residence and belongership at the same time.
That is correct.
But you mentioned, and I think this probably responds to Mr. Rowett's question as to the reason for the fast track, and you said that there was a significant backlog.
That's correct.
Thank you, Mr. Rowett.
I will come back to the fast track and ask some more details about how the criteria that were applied, but just whilst we're on the topic, what you seem to be suggesting, or summarizing, Mr. Smith-Abbott, is that you had essentially a dual process where someone could make a combined residence and belonger application.
That is correct.
Was it possible for someone who already had the benefit of residence to use the fast track process to make a belonger application?
Subject to correction by the chief, yes. individuals did take advantage of the ability, if they had residency, to then apply for belongership at that time as well.
And if you explained that it was the reason why it was time bound, if someone had made an application under the fast track program before the expiry of the end date, which ultimately was, I think, the 1st of February 2020, but that application had not been determined by that date, does it still fall to be considered under the amended law, or does it revert to being considered under the original section 16?
Okay, so to that answer, I'll yield again to the Chief.
Could you repeat?
I'll put it this way. I think, and I've been saying this, but I think when the Act was, when the second Immigration and Passport Amendment Act of 2019 came in, one of its effects was to extend the time for what we're calling the fast track program, right, so that it would end on the 1st of February 2020. If someone put in an application under the fast track program before the 1st of February, but it was not determined until after that date, was it determined under the amended legislation or under the law as it stood at the time that the application was actually decided?
No, once the application was in before the temporary time limit was ended, then those applications would have had to be determined on that basis and not go back to the original law.
If we do go back to the original law, which is now essentially what is currently enforced, with the addition of 16.5a, which is the 4th generation belonger basis. The common component when you're looking at belongership on the basis of tenure, whether it's not less than 7 years or not less than 10, is good character, isn't it?
Yes.
And also, someone must be ordinarily resident. Now, if we turn up 10.8 of the affidavit, it refers there to section 1610, which provides as follows. Well, I'll take it at 10.7. So under subsection 16.9 of the Act, there are different periods of ordinary residence, depending which section you are applying under. So if you're applying for belonger by tenure on the basis that you've been ordinary resident for not less than 10 years, you have to make sure that the number of days on which you are absent from the territory does not exceed 900 days. That's right, isn't it?
Yes.
Whereas if you're doing it on the basis of belongership, of the exceptional basis of tenure, where it's not less than 7 years, then you are, as long as you are absent from the territory for a period not exceeding 630 days, it's your application can still proceed. Is that right?
According to the law, yes.
Yes. And there is, again, when we're looking at seeking belongership by marriage, the time period in which the applicant is allowed to be out of the territory must not exceed 450 days. So that's the position. And what's said at 1610, and this is at 10.8 of the affidavit, is that notwithstanding the definition of ordinarily resident, an applicant shall be deemed to be ordinarily resident in the territory where he or she proves to the satisfaction of the Cabinet that he or she has been absent from the territory on grounds of illness, study, government service, or service in the armed forces of Her Majesty's government. And so those are, if you like, specific reasons which can mitigate absence from the territory. So if someone is studying abroad for an extended period, that will not count against them when you're calculating ordinary residence. Is that right?
Yes.
And similarly, if, for example, a public officer has to go abroad on behalf of the government, and again is there for an extended period, that doesn't count.
That is correct.
But is it right to read section 610 as essentially saying that it's only those 4 grounds that allow you to not have time counted against you?
Yes, according to the law, yes.
I mean, I'm struggling for an example, but if someone decides that they're going to go on a round the world trip for 3 years, the effect of that is that for those 3 years, they would not be deemed as being ordinarily resident in the BVI.
No.
I think, is that a no of agreement or a no of dissent, Mr. Penn? Would you agree with what I put to
I think it
you?
was a no of agreement.
Right.
You agreed with Mr. Rowett.
Right.
So in counting up these days for the purposes of defining ordinarily resident, that you can be out of the territory, otherwise you've got to be physically here. You don't count any days when you're out of the territory for these particular reasons. For example, if you're studying abroad.
Right.
Correct.
Yes.
But that's it. That that there are no other reasons that the days cannot count.
Well, let me put it this way. This law was written a long time ago, and it's kind of archaic right now. But from time to time, we amend the law based on situations that happen and stuff like that. So, in a situation like what we are now, COVID-19, persons could be out of the territory and could not return because of restrictions of, airports being closed, countries are in quarantine and stuff like that. So the law does not mention this, however, but in today's legalized law, it can be seen as one of the exception as well. However, it's not there. If you understand what I'm trying to say.
Yes, but if you take COVID as the example, though, did the department issue any kind of policy to say where someone can show that they are outside the BVI, wanting to come back to the BVI, but cannot for reasons outside their control, then we will not count that time against them?
Well, someone can make that application. It would be up to cabinet to make that determination. Perhaps cabinet may have the discretion to do so.
I see. All right. Thank you.
I'm sorry to interrupt. Does that mean that though even in the circumstances in which you've outlined, which are understandable, for example, if you're, as it were, physically locked out of the country because of COVID, I mean, I understand the merits of that, but you'd say that that's not something that you would take into account. It's something that the cabinet may possibly be able to take into account in their discretion.
Yes, what I would say to that applicant is to put it in writing, as Mr. Rowett just stated, put his reason why he was out of the territory, although it is not under one of the 3 exceptions that we read, and therefore it will be presented to cabinet, and I'm sure cabinet would be advised by the Attorney General on whether they has a discretion to to deal with it in that sense or not.
From that response, do I take it that you don't have any opinion as to whether Cabinet has got that discretion? That's something that the AG would advise Cabinet about?
Yes.
Fair enough, thank you.
If I just ask you to just turn up page 1346, please, Mr. Penn. It's right at the bottom. The question was posed to Mr. Smith-Abbott about the current test for ordinarily resident and whether it was mandatory. And if you go to page 1347, Smith-Abbott explained that and referred back to the legislation that we've looked at, particularly subsection 16.9, and pointed out that it has not been amended. And then in relation to the periods of ordinary residence required under different subsections, which is 10, 7, or 5 years, what's recorded is that the department is therefore bound to apply that definition as a minimum requirement. And by that, that's the immigration department, isn't it? And then you say, and it's something we'll come back to, in addition, in respect of tenure applications, it applies the benchmark of 20 years. I'll put that to one side because I'll ask you about that in a moment. But in effect, what that means is that if someone were to apply for tenure on the basis of having ordinarily resident for 6 years, that would disqualify them straight away. Is that right?
Yes, it was. Yes, it would be, because it would be under the 7-year.
The 7 or the 10
or the
year.
10-year.
Yes.
Yes.
Now, there are also, and we can jump back to 10.8 in the affidavit. Sorry, 10.9. What has been set out in the affidavit is reference to subsection 16.8, which gives guidance as to the factors that Cabinet has to consider when addressing applications made under section 16.1 to 4. And they are the economic situation in the territory, and whether it will affect, in effect, whether the application will prejudice a trade or profession that other persons are already engaged in. Secondly, whether the applicant has established a close personal connection with the territory. Thirdly, the applicant's character and previous conduct are unexceptional. And fourthly, the applicant's that whether the applicant's continued residence in and association with the territory may afford some advantage to the territory. So I suppose breaking that down, does it come to those factors are essentially whether the applicant could have a negative economic impact on others. So for example, if are you going to take work or a trade from somebody who's already here? Secondly, it's whether you have a close personal connection with the territory. Thirdly, it's essentially whether you are of good character, isn't it?
Yes.
And then fourth is whether continued residence and association with the territory will add something to the territory. Now, those are the factors that Cabinet under the Act have to consider. Are they, and we'll get into the process, but are they factors that the Immigration Department, when it's processing applications for belongership, will also have in mind?
Well, just to make it clear, the Immigration Department, as it relates to this application is purely not decision making and making sure that the application has all the criteria that is there, and processing those applications to go before the board and eventually to cabinet. So the immigration department is work for the belongers application is just purely administrative.
It is, Mr. Penn, but we shouldn't underestimate its role. So can I just finish? Because I think this reflects what you say. I think the Act, you reflect what the Act says. What the Act says is under section 16(2) that a person may be granted a certificate referred to in subsection 1 if he or she qualifies under subsection 2 or subsection 3 or 4 or indeed 6. So what an applicant has to do, he or she has to satisfy the conditions. If we're talking about the 10-year tenure, the conditions that are set out in subsection 3, they have to satisfy those conditions. As I understand it, your role is to see whether they satisfy those conditions. But once they satisfy those conditions, they still aren't entirely through the process, because under 16(2), there's a discretion. A person may be granted a certificate if they satisfy all of the conditions, and it's that discretion that's exercised by the Cabinet. And in exercising that discretion, they have to take into account the factors set out in subsection 8.
Yes, exactly, and I agree with what you said. But even though the application comes and it is scrutinized by myself or the department, I still see it as purely administrative. Yes, I follow the law and make sure that that all the criteria are satisfied, and and then after that, those applications are processed and and go before the board. So that's why I said it's purely administrative, even though it has to be scrutinized by myself and the department.
Because the final assessment, the final judgment is made by Cabinet.
Exactly. Yes.
No, I understand that, Mr. Penn.
Yes.
Thank you.
I think probably I set this hair running, Mr. Penn, by you not being clear about the distinction between the Immigration Board and the Immigration Department. So, I mean, it comes down to this, isn't it? That there are 3 elements to the process. The first part will be the Immigration Department scrutinizing the application,
yes,
and putting it together.
Yes.
And the second part is the work of the board,
yes,
which will involve, as we'll come to, an interview process and an
yes,
assessment,
yes,
and making a recommendation.
Yes.
And then it then goes to Cabinet, who can either accept or reject that recommendation.
Exactly.
So I think you're right that in that sense, the work of the department is administrative, in that you essentially operate the scheme, but recommendations and decisions are made by others.
Yes.
No, that's very helpful. Thank you.
But I think the reason I asked the question in the first place was the extent to which these factors inform the process, because under the Act, they determine how Cabinet will approach an application. But in terms of when you and your team are assessing an application, or indeed when the board is looking at an application and deciding whether to make a recommendation or not, would it be fair to say that these are factors that inform the process?
Could you go over again?
There are 4 factors under the Act.
Oh, yes.
Yes.
Right.
So leave Cabinet to one side.
Right.
But in terms of the approach adopted by the Immigration Department and the approach adopted by the Immigration Board,
Right.
do these factors inform that approach?
Yes, because in processing the applications and getting them ready to go before the board, and the board meets to make recommendation, the board will take into consideration a number of factors as well, and some of those factors, would include, but not limited to, some of the things that that cabinet has to take into consideration. So the board will also look at a person's character, and they will look more keenly into a number of things procedurally that that will cause them to make a recommendation to cabinet. And therefore, it would influence their mind whether to make a recommendation or not to recommend.
I see. I think we'll get into the detail of the process shortly.
Yes.
But if I take you, Mr. Penn, just to 10.4, so it's page 1333 and paragraph 10.4 of the affidavit. So we've dealt with the two subsections which can give you belongership by tenure. And there is also, just to deal with the other ways in which you can get belongership, there's the further exceptional basis, which is subsection 6.5, and that's where someone has made significant and consistent contribution over a period of at least 50 years.
Yeah.
Now, I think at one point during the fast track period, that was shortened to 20 years? Is that right?
Well, Commissioner, if I may actually address this particular exceptional case. This was in the context of Mr. Lawrence Rockefeller, who was a significant contributor to the development of economic activity in Virgin Gorda and protected areas, establishment of protected areas system in the Virgin Islands, along with the late Joseph Reynolds O'Neill. So in this particular case, which based on my background disclosed before, Cabinet felt very strongly that the bar will be set very high for an individual of such stature and who would have made a sterling contribution to grant and make it very, very clear that the strength of that contribution for 50 years would be significant enough to grant belongership on that basis, where the other factors that we've been considering, being ordinarily resident in the territory, etc., would not necessarily factor into that decision. And as far as I'm aware, that exceptional case is the singular example of that such a grant of Mr. Rockefeller.
But do either you or Mr. Penn know, as Mr. Rawat suggests, that in the temporary provisions in 2019, was that reduced from 50 to 20 years, or was it not?
If I take you to page 1493.
Yes, thank you.
Right, so under those circumstances, yes.
I mean, but as I understand it, it's reverted back to 50 years.
That's correct, yes.
But also what's I think more important to say about that provision is that it isn't one which requires an application. It's essentially at the gift of cabinet, and it falls outside the processes that we are discussing today.
That's correct.
Yes, and it didn't simply reduce the 50 years to 20 years, I don't think, because you also had to be ordinarily resident for 20 years, whereas under the continuing subsection 5, it was simply 50 years.
Correct. And my
Sorry,
understanding,
50 years contribution.
correct, and my understanding of that particular process is that even if with the reduction from 50 to say 20 years, all of those individuals sort of still applied even under the fast track. So the waiving, so to speak, and again, subject to correction, but the waiving as such would have still required some application during this particular period for the exceptional basis.
No, you're right, because the temporary section, the temporary subsection 5 refers to a person who applies.
Correct,
So
exactly.
right.
So you would be still subject to an application. So
it's a different thing.
yes, exactly. It's just that the provision actually would have been reduced from the very high bar, as explained, 50 to 20.
But there are two other bars.
Correct.
Two other criteria.
Criteria. Yes.
Ordinary residence for 20 years and an application.
Correct.
Thank you very much.
Thank you. If we move on, just I'll take you back to page 1331. And it's this new 16.5a, which is the fourth generation grant. Just again, does that require an application, or does that require a just? Yes, it does require an application. I'm not reading it properly. So that requires an application, but all it requires in terms of being successful, subject to cabinet's discretion, is that the person can show that they're a great grandchild of a person who belongs to the Virgin Islands. Is that right?
Yes.
There's no other categories at all, for example, good character or ordinary residence or age at all?
No.
And then I think marriage we've dealt with, and one of the factors, as we've seen, is that good character does come into play there, because if the spouse of the belonger has been sentenced to imprisonment in any country for a criminal offence for a term of 1 year or more, that could count against them.
Yes.
Could I take you please to paragraph 9.3? I think dealt with the legislation, and it's just turning to policy. Paragraph 9.3 refers to events in 2004, which culminated in the Executive Council, as it then was, issuing administrative guidelines. Can you help at all, either Ms. Smith-Abbott or Mr. Penn, as to the circumstances in which those guidelines were issued, other than what's in the affidavit?
As it is understood at that time, there was a backlog of applications, and in establishing an orderly process for the consideration of those applications at that time, Cabinet would have been minded to establish at least the order of precedence in terms of the consideration of those applications by at least disclosing the fact that there would be applications that would be considered in chronological order in descending manner, so that the 20 year benchmark and above became at least a means by which the department would have been constrained in terms of resources to process those applications, as the Chief Immigration Officer would have stated in his submission just now, that of course the department would be administratively responsible for vetting those. And with a large number of applicants, there will need to be a way in which you can rationalize how those applications will be systematically addressed. So in doing so, at least there was some criteria established to that, as I understand it, to at least consider the backlog of individuals who would need to be considered for belongership at the time.
I mean, looking at the original documents, my understanding, there was a backlog, and that's what triggered the guidelines. It seems, but there were a number of steps that were taken to get rid of the backlog. I forget precisely what they were, but I mean, 50 applications a month or something would go to the board, to the board, and so on. And also the application would be taken in chronological order, oldest first.
Yes.
Yes. But if you take the applications oldest first, the 20 years benchmark wasn't a criteria for prioritization, because the priority was the oldest applications. You don't have to put an artificial line at 20 years. The 20 years came in, didn't it? Because it was said after the backlog has been dealt with, because they were confident that the steps would get rid of the backlog, then unless the applicant had been ordinarily a resident for 20 years, then the application wouldn't be considered. It would be shelved.
Yes, the functional and practical implication of that policy would create that condition, yes.
But it wasn't prioritization. It was a shelving of all of those applications until 20 years had elapsed.
Yes.
We can see the guidance or the administrative guidelines at 1576 in that bundle. Which I think is dated, yes, it's dated the 24th of August 2005. Now, and the guidelines that we're really interested in start on the other page at 1577. But there seems to be some variability as to what date these guidelines began to be applied. So we see it's dated the 24th of August 2005. The affidavit mentions sort of 2004. There are other documents which sort of refer to 2004. Were you able to establish any definitive date from which the Immigration Department started applying and the Immigration Board started applying the guidelines?
So what we were able to establish based on at least the records available to us, that in a practical sense, these guidelines became effective sometime in 2005. So I know that there are some dates that place the effective start later than this, but at least from what we've been able to glean from the records, it appears that most of the implementation of the guidelines would have started in 2005, late 2004, 2005, which would be consistent with the extract, of course, which would have been issued sometime in August of that same year. So end of 2005, thereabout, you would have had some activity.
But the 24th of August.
Sorry, 2004 into 2005. Exactly. I'm looking at the date when the.
Yes, because the 24th of August 2005 date is slightly misleading, because this is an extract from the minutes of the Executive Council meeting of the 27th of October 2004, and also the memo that's been considered is 367 of 2004. So that fits in, Mr. Smith-Abbott, with what you've said.
Yes.
End of 2004.
Right, and it becomes difficult to establish the effective date because some records may have been lost. There's disclosure of the fact that the Immigration Department had incidences where records were lost due to unfortunate circumstances. So whilst the effective date, whilst the memo refers to 2004, the implementation, as we've at least been able to understand, may have started sometime in 2005.
On the same document, but a different point, in paragraph 1345A, it says the board, that's the Board of Immigration, has noted in its first recommendation the need to formulate immigration policy as part of the territory's national goals and objectives and not in isolation. One would imagine that policies concerning both residence and belongership might fit in to a broader policy, a broader national policy, based on things like expected population growth by birth and immigration, by the growth of the economy, all sorts of things that might result in an immigration policy as to how and how many belongers, how they should be processed, the criteria, and how many belongers there should be allowed in by way of certificate, to be part of a sort of broader policy as to where all of this is going over the next 10, 20, 50 years, or whatever it is. Do you know of any such broader policy? A broader policy than the policies that go purely to belongers. This seems to touch upon it a bit by saying no more than 25 persons per year. It doesn't really say how that's calculated, but that looks as though it might be part of a bigger picture. Mr. Penn,
well, if I may, Commissioner,
yes,
actually, to this point, earlier testimony would have alluded to the significant point in terms of criteria that you want to ensure that there is nothing that adversely impacts existing sectors. So if we just simply revert back to that testimony, part of Mr. Penn's testimony and as the line of questioning, I can speak directly to the fact that around this time you had a broad national development planning process taking place, which would have been the National Integrated Development Strategy. That was a project actually that was spearheaded by the Economic Development and Planning Unit that would have fallen at the time, I believe, under the Chief Minister's Office. And that was a broad consultative process where varying sectors would have actually held significant meetings looking at the overall strategy and the direction of the territory. So it's against that backdrop, and that was a multi-year project that culminated with the publication actually of the National Integrated Development Strategy. So that I think would have informed some of the allusions that are being made in this particular paper with respect to how the national goals and objectives would have informed the immigration policy at that particular time.
But is there any such policy now, any such broad policy now?
Yes, actually, well, there's a national development planning process that is taking place currently under a project under the Premier's office. That is an organ of a much broader national development planning strategy that is being formulated currently. So even in today's environment, you have a parallel, similar process as would have been the case at that time.
But that's looking at the future and what might happen in the future in terms of policy. But is there a policy now into which the immigration policy fits? Is there a policy which sets out the broad aims of the territory over the next period of time, which informs the immigration policy that we want lots of people to come here, or we don't want lots of people to come here, or whatever it is?
There is such. However, I have to say that it's not been directly linked to an immigration policy, because effectively, as I understand it, these guidelines constitute, to a large measure, the immigration policy. So
These,
correct.
yes.
However, there is also the National Physical Development Planning process that looked at the time, and this is a relatively recent adopted plan that looks at projections based on capacity, both from a natural resource perspective in terms of looking at human settlements, in terms of looking at what the broad national objectives may be. And that is actually an input into this other process that I'm alluding to, which is still ongoing, the National Development Planning process. So there is a much broader policy framework being developed that a presumptive immigration policy will fit into.
So as I understand you, Mr. Smith-Abbott, there is something which is ongoing, which is going to result in hopefully in some policies in the future. But at the moment, we simply have this.
Right. So in terms of the strict view of an immigration policy, this is it. Yes.
This is it. And there's nothing which, because having a backlog of immigration, having a backlog of belonger applications or residence applications doesn't address the question of how many people it would be good or sensible or wise or even politically what wanted. It doesn't address any of those questions.
I would have to say that the direct link of what is a desired population number, the complement of native born, say, to those that you assimilate and integrate into the community, so to speak. Those very discrete questions are yet to be answered. However, what I can also say is that there are instruments of policy that have been developed and are being developed in the form of the two strategies and policy statements that I've referred to, namely the National Physical Development Planning process, which there is an adopted and approved plan. That was the subject of a project that culminated in 2018-19, I believe. And then, of course, the ongoing National Development Plan that will also speak to how Sustainable Development Goals will be incorporated. It is intended to be an instrument that will straddle administrations, because really and truly the horizon for implementation of such a plan and such a strategy is long-term.
Yes.
And under that process, I would say that you can reasonably then anchor an immigration policy that at least takes the aspirations as stated in those documents and places that into an administrative framework, which may then also result in some amendments to the Act.
Very helpful. Thank you very much, Mr. Smith. Mr. Rama.
But I mean, the point is made. It probably comes into play towards the very end of 2004. But it does seem to be that those administrative guidelines that we see set out at page 1577 have continued to be internal policy since that point.
That's correct.
And Commissioner, for your note, we don't need to turn it up, but there's a document at page 1618, which is headed, it's an appendix to, I think, a cabinet memo, yes, but it's headed Immigration Policy Guidelines, and it then repeats the administrative guidelines that we've been going through.
May I just have the cabinet paper number?
It's, if you turn one, it's page 1618. I don't have the,
Oh, the cabinet, yeah.
because I think it's,
Yes.
so at least, I mean, that's recorded as Immigration Policy Guidelines meeting of 15th of June and 20th of July 2017. So it certainly just be, that's an example of it.
Reiterating the older
guidelines
policy.
through the years. But I think that the point that's made, Mr. Smith-Abbott, in your affidavit, and this is at page 1332, and I wanted to clarify this with you a little, if I may, but you make the point that these administrative guidelines, as we've been calling them, are not all followed in practice. And so if we look at them, you make the point that A and B dealt with persons who'd applied for belongership before the 1st of January 2003, and D was a direction, in effect, about dealing with an outstanding backlog of applications in chronological order and with batches of 50. You make the valid point that those two guidelines would have been overtaken by time.
Right. So under
A and B.
9.3A, you have that the quota of 25 persons per
Sorry,
year.
I'm.
Oh, you're looking
sorry,
at.
I may be confusing you.
Okay.
If you keep your thumb or your finger at page 1332 and just turn up 1577, please, Mr. Smith-Abbott.
1577.
So that gives us the 2004 administrative guidelines. In your affidavit, by reference to guidelines A and B, you make the point that those would not, or you make the observation that they may no longer be relevant because all the applications in question would by now have been dealt with.
Yes.
But taking the others, there's what you've called 1347D, which is in the case of those who applied for resident status after the 31st of December. I'm sorry, I'll read that again. In case of those who had applied after 31st of December 2002, recommendations for resident status should be made for no more than 25 persons each year. Now, that is not something that we're not looking in too great a detail at resident status, but is that policy still applied? So
the policy in relation to consideration of no more than 25 persons per year. Is that the?
Yes.
Yes.
So
So that's not adhered to. Yes, that's the case. That is not adhered to.
And looking at D and E, there was a policy both for resident status and then for belonger status. Resident status being a precondition
To belongers.
of 25 persons per year, and both of those have disappeared as conditions over time.
That is correct.
Thank you.
Could we take a short break soon?
Yes, certainly.
Sorry, I was just about to.
Mr. Castan, yes, I got that in mind, and we're overdue. The stenographer needs a break after about an hour, and we've been going for a lot longer than an hour. So we'll have a 5-minute break now, and then return. Thank you both very much. Yes, we're ready to resume. Thank you, Mr. Wright.
Thank you. Mr. Smith-Abbott, just sticking with the administrative guidelines briefly. You've explained that in relation to the cap of 25 persons for either resident status or belonger status, that isn't applied anymore. Do you, or were you able to establish when that part of the guidelines stopped being applied?
Well, again, yield to the Chief Immigration Officer, perhaps he may have a motion.
I wouldn't be able to pinpoint that accurately myself, as I've been chief from 2014 onwards. Those years before, I really can't attribute to when that had stopped. But
Did it stop before 2014? Did it stop before you took over in 2014?
yes,
The last guideline is that in all cases, periods of continuous residence in the territory means a maximum of 90 days absence in any calendar year, excluding absence to pursue further education. And the point that's made in the affidavit, Mr. Smith-Abbott, is that simply echoes the provisions of the legislation in respect of continuous residence.
As I understand it.
Because, and that harks back to if it's not less than 10 years, you have got to be ordinarily resident for it's a maximum of 900 days. But in terms of when an application is being considered, is it checked whether someone is away for more than 90 days in a year, or is it just, for example, in relation to belongership by tenure? Does the period of time away exceed 900 days? How is it assessed?
for which one, the 90 days?
Yes, I mean, when you're looking at scrutinizing an application, is the question, has someone been away for a period of time not exceeding 900 days? Or is the question, in each calendar year, have they been away for no more than 90 days?
Right. So upon application, when someone submits an application, part of the immigration department is to pull that person file, because most likely they would have a file with immigration. Every year they have to renew their entry permit with us. So therefore we will go through that file to make sure that they have been continuously residing in the territory for that period, and look for any absences from the territory that would fit in those categories that could in some event disqualify them from submitting the application, because they have been out of the territory for such long periods. So part of our administrative work is to scrutinize the application and the person file, and to look for those information.
And it's point C on the administrative guidelines, which reads, once the backlog of those identified at B had been cleared, the board should make recommendations as applicants reach the 20th anniversary of their arrival in the territory after the normal screening process. And that is the basis of the benchmark that has been applied since 2005, which is that you consider applications when somebody has 20 years.
That is correct.
And looking at this document, which Mr. Smith-Abbott, you said is the policy, there's nothing else. A and B have run out because of time. D and E, 25 persons, no longer applied. F merely reflects the Act. So the policy is C, isn't it? That's the remaining policy.
That is correct.
And has that policy been published at any point?
No, it has not.
Were you in the work that was undertaken for the affidavit able to establish why it wasn't published?
As I understand it, the administrative guidelines were to then be followed by amendments to the Act. And those are disclosed, of course, further in the paper and under point 1348, along with other elements that are described in that captured in that section of the cabinet paper. So at least in establishing why this policy only remained an internal document, the working guideline, so to speak, in terms of the lack of a publication really stems from the fact that it was never really acted on as intended by cabinet to result in that amendment. I'm not certain why it would have not happened, but at least.
So, and I think you're just looking at the documents. That's where you're getting your information from, your views from, but it makes sense. You think that the policy was introduced. There was a proposal to amend the Act to bring the Act in line with the policy, the 20 years. That, for some reason which is not known, was never followed through. And then the policy was never published. And again, probably you don't know the reason why it wasn't published.
Yes, I wouldn't be able to elaborate much further than what I have.
Exactly. Yes. Okay. Thank you.
And this takes us, Mr. Smith-Abbott, to back to 1332 of the affidavit, because having addressed the administrative guidelines, you comment or observe at your point G that it's regrettable that the internal auditor's first two recommendations, and this is a reference to an internal audit report in 2012, that her recommendations that the law be updated, which might include amendments to reflect the practice of the department in respect of periods of residence applied as a benchmark, have yet to be implemented. You conclude that the immigration law of the Virgin Islands is currently under review. Funding exists for a consultant to assist in this process. We await guidance for the Attorney General's chambers as to a possible candidate to act as that consultant. And is that still the point you're at? Are you still waiting for guidance from the Attorney General?
That is correct.
And what is the, have you been able to decide or determine what the consultant will be asked to do?
Well, let's take a step back. And I think that just for awareness and an understanding of the incremental steps. So you have these policy guidelines, which have not been published, which have been acted on, obviously, over the period with respect to at least when applications would be considered. So the effective measure here is that they've created a benchmark of 20 years for consideration. There was the identification of the need to implement the policy statements that are contained in that cabinet paper, and these would have been identified by the the internal auditor in the 2012 and subsequent follow-up in 2014. So therefore, on the strength of all of these recommendations, there's been at least some ongoing dialogue about the need to ensure that all of this volume of work is reflected accurately, initially in policy, and then subsequently by the required amendments in the Act that will give effect and better legal standing to act in the manner in which administratively by the board, by the department, and then subsequently by cabinet. So this is now a matter of what this particular disclosure under G will refer, that the immigration law of the Virgin Islands is currently under review because, of course, we would have been engaged in this process, and that the consultancy then will result in at least, and this will obviously be will have to be the subject of terms of reference, which will still have to be developed in tandem with the Attorney General's chambers. But if I was to then blend from other processes, obviously we will have to look at the context. And there's a lot of work actually that would have already been done with respect to the issues that need to be addressed. If you look at the consultation process that actually was undertaken at the time when the fast track was being considered, you had massive amounts of public engagement and dialogue at that time. And I think that that would be a significant input into any review of policy, because the notion that we're starting from scratch would be a totally false one. There was quite a lot of public engagement and a lot of input and feedback received even at that time. So I think that it's reasonable to suggest that any review of the immigration law, which would obviously have to be preceded by a policy, would take that volume of work, that would take the input and feedback received throughout that process to inform what an immigration, the amendment of the act may entail. And that consultancy, the consultancy would effectively have to look at some of these other inputs that we've already alluded to earlier. So we'll have to look, for instance, at the National Physical Development Plan, for instance. So we'll have to look at the National Development Plan once complete to gain a sense of the overall direction. So it's reasonable to suggest that the terms of reference of a consultancy would have to look at all of this volume of work already done to inform what are reasonable policy objectives to be met that will inform an eventual amendment of the act. Of course, because you have this functional benchmark of 20 years, that would also be a significant input into any policy guidance, I should say, as well.
That's looking to the future, but at the moment, and really for the last 20 years, since 2004, 2005, the guidance has been the criteria set out in the Act, the factors set out in the Act, which we've looked at, I think, in section 16.8, and in terms of policy outside the Act, one policy, that is that until the 20th anniversary of arrival in the territory, residents in the territory, the application won't actually be considered. That's the only policy outside the Act. That policy, and I've received some legal submissions on whether the policy is unlawful. We needn't go into that, but it's extremely unfortunate, isn't it, that the only policy was not publicised, and therefore applicants who may have put in their applications after 10 years didn't know that they would be put on a shelf for 10 years. That seems to me to be very unfortunate.
Yes,
I think it's any observations you want to make, but it's not ideal.
Yes, I think that the potential unlawfulness of consideration, this is in the context of consideration, whether there's an expectation that after 10 years, at least I can reasonably be considered for belongingship. And yes, I am aware of that submission. So to the extent to which it is unfortunate, as you characterized, it is unfortunate that a much longer period has been imposed for consideration, not necessarily grant, which is totally separate and distinct, right? It is unfortunate. I look into the future, I think that what I would like to do at this time is to perhaps speak to what the Immigration Board and Department have been doing with respect to a little more than just simply the 20-year benchmark, because inherent in the practice, there is, of course, the due care and concern with respect to the actual character of that individual who at some point will be integrated.
I think we'll come on to that, because I think Mr. Abbott may have some questions on that aspect. But in terms of unlawfulness, and as I say, I don't want to get into the submissions. I've got the submissions. I'll make of those what I can. But generally speaking, as a proposition of public law, if the state, if the government have a policy which they apply, which is not published, that's unlawful. And here, there is a policy. It appears arguable that it's contrary to the statute, but it is an unpublished policy. Certainly strongly arguable that it's unlawful, but it just seems to me to be very unfortunate because people have been making applications, leaving lawfulness aside, people have been making applications after 10 years, not knowing that they'll simply sit on the shelf for a long time. As I said, that's not your, certainly no blame attaching to you, because that's the policy to which you're working, but it just seems to me to be very unfortunate, that's all.
You've spoken, both of you, about the backlog, and obviously the 2019 effort to reduce what was a significant backlog. But did the fact that the use of a benchmark contribute to the backlog? Because you would have somebody applying when they had completed not less than 10 years, and effectively have their application be put on hold, and it would just be sitting there until the 20-year benchmark was reached. And that presumably must have happened every year. And so you would actually build up a pile of pending applications. Do you think that contributed to the backlog at all?
No, I don't think so. But what I would like to say here is that even though the X would state 7 or 10 years, and the guidance talk about 20, although it wasn't published, we're a small community, and persons would get hold of what is happening in immigration, because a number of persons would probably inquire or call or come to the department, and therefore the word or the message would spread in the community and say that this is what is happening with immigration, with submissions of applications and stuff like that. So at this stage and point, the population knows that when submitting application, they have to submit it, at their 20th anniversary. Not saying that it's correct, because you talk about it being published. We have no record of it being published, and however, we have been carrying out this policy in that light. And I can say for now, we do not have such a backlog per se, because we discussed earlier that the policy talk about 25 applications and stuff like that. But that has been done away, because we saw it more efficient to try to do more applications, because year after year, more applications will come into the territory, to the department, and therefore we had to act in terms of processing those applications as fast as they come in, to deal with them as quickly, and efficient, to get them processed and go before the board and before cabinet.
But in respect of that, Mr. Penn, firstly, you say that people know that in practice it's 20 years, not 10. But it seems to me that applicants are entitled to have a policy that's being adopted, published, as opposed to relying upon rumour as to the practice in the immigration department. And in terms of the backlog, just to go back to Mr. Rawett's question, when you have a backlog, that presumably is a number of applications which are pending, and that surely includes those applications that are in the 10 to 20 year period. So that the backlog, whatever the number is at any time, includes people who have applied after year 10, and are waiting for year 20. So the backlog number includes these people who are just sitting on a shelf.
Well, I won't go away from the fact, Commissioner, that yes, it should be published, and as I've stated, we're a small community, and the word would get around. But from my recollection, I cannot state categorically that that there was a number of applications, persons who made application, after 10 years. After 10 years, that could have probably been the situation before 2004. Before the policy, and that's where the backlog perhaps came by. However, that backlog was dealt with, and I cannot recall applications coming into the department for 10 years or 7 years in the department.
Thank you, Mr. Penn. Yes, Mr. Rowett.
If we could just turn, and probably this may fall into the ambit of Mr. Penn's work, and just an outline of the application process as it currently stands, and that's primarily focused on belongership by tenure. But as a starting point, I'm right, aren't I? And I apologize if I'm repeating myself, but unless you are going to get status under 16.5, which is the Rockefeller provision, you are going to have to make an application.
Yes.
And there are, I think you've said this, but there are instructions on the Immigration Department's website, aren't there? At least an applicant can find the relevant forms on the website, is that right?
Yes.
And I think the affidavit acknowledges that the website needs updating, but leave aside the policy, it's right, isn't it? You don't publish the statutes on the website.
The immigration statute, no, but it should be part of our process to have it on the website.
Do you know where someone would go if they wanted to find a copy of the Act?
They would either come to the department or to the AG chambers.
And members of the public can go to either?
Yes.
And in fact, I mean, in fairness, you do say, or the affidavit does say that applicants are encouraged to visit the Immigration Department. Yeah. How are they encouraged?
Publicly, if the department have any announcement that they would like to make, from time to time, persons are encouraged to come to the department if they have a question, or call. Numbers are given, and they can call or come to the department if they have a question, of any process that would affect them immigration-wise.
And again, an outline is that the applicant has to use the required form and has to provide all the necessary documentation.
Yes.
Now, the internal auditor in 2012 suggested the form was outdated. Do you know whether the form has been updated at all since 2012?
There was some minor alteration to the form, as to the information that person has to provide that was put in front of the form, a checklist as to what persons need when submitting the form to the department. So that was an improvement. So when an individual collect the form, they know exactly what they have to submit with the form. So I think that has been helpful.
If we look at page 1337, paragraph 15 sets out the process, and as I understand it, Mr. Penn, is that once the form is received, it will go to a member of the Immigration Status Unit for review, and that person will check that all the necessary documentation has been provided. Is that right?
Yes, that is correct.
And what's recorded at 15.3 is that after the form has been submitted, the applicant is notified by email of their application status. And by that means whether they've submitted all their necessary documents or whether additional information is required. Those who, it's said here, have applied prematurely, which is before they've reached the 20 year of residence in tenure cases or the 5th year of residence in marriage cases, are informed that the application will be placed on hold until the appropriate period can be demonstrated. And then the application is then placed in a queue to come before the Immigration Board. Now, I think if you look at 15.5, it says that under the Act, the Board is empowered to make such inquiries as they consider expedient. Now, we'll come to the process of the Board in a moment, but outside what the Immigration Department gives the Board, does the Board in practice make any further inquiries itself?
There's a process before it goes to the Board. There's an interview which includes a Board member, a person from the status unit, and in some cases someone from the surveillance unit. So board members who sit would normally conduct the interviews, and therefore whatever is gleaned from the interview, then that would be put forward to the Board in terms of in the overall recommendation process of the whole Board.
Could I come back to that, Mr. Penn? I just try and take the process in order. So I think when the internal auditor produced her report in June 2012, she noted that the Immigration Board was using various tools to evaluate applications and then to make recommendations. And those were what was called a point system, an interview, and a cultural questionnaire. And is that the same system that's still used today?
Yes.
And so, as I understand from the affidavit, the current process is that the applicant attends for an interview.
Yes.
Which, as you say, will be actually it's not led by the Immigration Department. It's an interview with a member of the Immigration Board.
Yes.
But you will have someone there from the status unit because to administer the cultural test, as it's now known. Is that right?
Right, and also to take notes.
What's the purpose of the cultural test?
Well, one of the purpose of the cultural test is to it goes to show that if you desire to make the territory your home, your intention to make the territory your home, the intention is to see how much you know about the territory, and not just you're here for 20 years and you're expected to get a residence status or belonger status, and you don't know anything about the territory. So which means is, it's like giving a status to to someone in the territory, of such high magnitude, and they don't have any ties to the territory, or they don't know anything about the territory. So therefore, that is one of the criterias that that we want to make sure that if persons state an intention that they wish to make here the permanent home, one of the criterias is that they have to be versed, or they have to know something about the culture of the territory in order to do so.
It's sort of evidence of commitment to the territory,
Yes.
really. Yes.
And so presumably it tests, for example, whether they know something about the history of the territory.
Yes.
And and the affidavit explains that the cultural test has several
Variations.
versions to
Yes.
help prevent cheating. And it consists of 10 questions related to the Virgin Islands culture and government. And the applicant has 10 minutes to deal with it. Just clarify this though. Under or is there a pass mark for the culture test, the cultural test?
The cultural test is out of 20, and the pass mark is 10.
But what the affidavit records, and this is at paragraph 1510 on page 1339, is that a low score on this test doesn't automatically prevent a person from being awarded belonger status. Will there be a score that is considered so low that it will lead to the person not being recommended full stop?
Well, we take the point system, the whole point system into consideration. So the cultural test is part of the point system, but we take the point system cumulative points, that are built up. However, if where a person scores low on the cultural test, yes, it can be looked at that that person is in the territory for a long period of time and they don't know anything about the territory. However, it is not outright a disqualifier, because, as I said, it is part of a cumulative test from the point system.
So is it fair to say on the point system that it is, as you say, cumulative? I understand that. So that the cumulative score matters. But if any individual had a very low score, possibly on any, or at least more than one of the subjects, that might mean that he or she would fail overall.
Well, not necessarily, because they could have a very low score on one matter, but the other scores are very high.
And so what matters really is the cumulative score?
In a sense, yes.
Yes. Thank you.
I mean, what's also said is that the department's prepared to be flexible depending on any disability or lack of aptitude suffered by any particular applicant. And this is in relation to sitting the cultural test. How does that flexibility work? Is that in terms of giving someone more time to do the test, or?
Well, there could be persons who are dyslexic and or have a challenge, and therefore we would have to improvise and try to deal with that person on a case-by-case basis.
And do you have any written guidance in relation to how you deal with such situations, or is it just you have to deal with it on a case-by-case basis as it happens?
Yes, case-by-case basis. Yes.
Now, on that day, there's the cultural test, but there's also the interview.
Yes.
And we'll look at the points-based system or point system in a moment. But our interviewer is given, as I understand it, the interviewer is a member of the immigration board.
Yes.
Is the interviewer given any written guidance on how to conduct the interview or otherwise assess the candidate?
Yes. Yes. They do have written interview guidance. Yes. And they can, you know, ask questions outside of the guidance that they have as well.
I see. Do you ever conduct telephone or Skype interviews, or does it have to be face to face?
There have been occasions where there were interviews conducted on Skype or other means, which is very rare, but I know that there have been interviews conducted in that way.
If we turn up 1569 in the bundle, I think this is the point system form. In the affidavit, it's described as being used to capture the applicant's responses in the interview. Obviously, does anything else happen in the interview other than the process of completing this form?
Well, this form is completed, you know, based on the questions that are being asked, and then the answers provided, and then therefore the points are added up. However, you know, during the interview process, there are other questions that the board member may ask of the applicant, you know, to make sure that this applicant, has, submitted an application and has such an intention to make, the BVI their permanent home.
So it's not just a question simply of interviewer going through and answering the questions and filling in the form. That they'll look at the application form. They may ask additional questions.
Yes.
And the officer from the status unit is there to make a note of the interview.
Yes.
What would you say, Mr. Penn, is the benefits of having a point system?
The benefits of having this point system is to rate the application and to give validation that that they have an intention to make the territory their permanent home, and also to to look at the fact that we are dealing with persons who may not just come to make an application because of application's sake, to ensure that that those persons are genuine applications, and to make sure that there's no false statements or anything they have made to the department or on their application.
We spoke about the factors that apply to cabinet. Remember, I asked you whether they inform this process. Some of the answers you've given suggest they do, because you've spoken about people demonstrating their commitment to the community. You've spoken about what a significant step a grant of belongership status involves. And so would it be fair to say that as the design of this form and the purpose of the interview is to look at whether the question of economic balance. Will an applicant cause a loss of revenue elsewhere? Look at personal connection, look at character and conduct, and look at whether they will benefit the territory.
Yes, I would say that, and I would also go back to say, one of the purpose of the form as well is because the information from the point system, most of it, goes on a person profile that goes to cabinet, and therefore it gives cabinet an informed data to make a decision on whether to approve the application or not. So it is very important to cabinet as well.
And what we see at 1569, this is the form that's in current use, is it?
Yes.
You can see that there are what can be called factors, a number of them, which attract a certain amount of points. And underneath there's a box which says explanation. And this must be guidance to the interviewer, is that right? Things to keep in mind.
Yes.
Aside from what's written on the form, does the interviewer get provided with any other guidance?
They get guidance on, the type of questions, that they can, some generic questions that they can ask. However, they're not, they can change and ask their own questions or formulate their own questions.
I see. And we can see if we take the first page as an example, it's got its employment status attracts 20 points maximum, but a retiree gets 10 points. You can be full-time, part-time, or none. Is it just up to the individual interviewer to decide how many points to allocate?
Well, the points allocate to the information that is extracted from the applicant, and then the points are awarded in that sense, because you can have someone who have applied and they're currently unemployed, because of COVID or for some other reason. And so that person would get zero for that. Okay.
So if you're unemployed, you'll get 0.
Yes. But as I said before, if you get 0 there, it doesn't necessarily mean that you have been disqualified. I mean, you're unemployed for a good reason. A lot of businesses have closed down. And therefore there are other points on the point system that can bring you over that threshold, in terms of a pass mark.
I mean, the explanation suggests that you get 20 points if you're in full-time employment and you've paid tax and you've paid your SS contributions. That's at the one end of the scale.
Yes.
At the other end of the scale is a failure to secure employment without any reasonable excuse. That's at the no point end.
Yes.
And then there are going to be gradations in between. For example, somebody who's been in full employment but isn't fully paid up on tax or SS contributions, or someone who is temporarily unemployed because of something like COVID or something like that. So there'll be gradations between those 2 points.
Yes.
Yes.
The form, if we turn to 1572, the form seems to suggest that you can lose points as well as gain them, because if you look at 6, where it says assimilation, and then there's not a part of the BVI community, this should be points deducted. So somebody could, if the interviewer forms the view that somebody after 20 years is actually not a part of the BVI community, and has made no efforts to become a part of the BVI community, does that mean that the interview could actually give them a negative mark?
Well, it all depends on how much they have scored already. But if they've scored high, say maybe 90, 80 points, it doesn't necessarily mean that it will take them dramatically, in a failure mark or whatever the case may be. But it is expected that if you're going to be here in the territory for 20 years, as part of your wanting to make here, permanently your home, you're expected to, give back to the community or be a part of the community.
But if you can't show any evidence of that, I mean, let's assume that you have just spent your time, in full-time employment on one of the islands building a rocket, but you haven't actually spoken to anybody else at all. So you can't show any evidence that you've assimilated with the community. I mean, let's assume you've got the maximum 20 points for employment, but you cannot under 6 show assimilation. Is it open to the interviewers to say, I'm actually just going to deduct you 10 points because you haven't assimilated?
Well, there's no points allotted to under 6, and therefore it's discretionary, based on the information based on the information that would come out in the interview. As you suggested, there could be somebody who has been here living for 20 years, working somewhere, and because of their work and because of what they do,
or because they just don't want to.
It could come to that as well, but that information would have to come out in the interview, and then a determination will be made.
Okay, because the other area which seems to be deductible is item factor 9, which is headed BVI of police record, deductible points, see schedule. And what we've got on page 1574 is a list of offences, and it appears that you can lose points if you have committed various offences. And there seems to be a range. Am I reading this right, Mr. Penn?
Yes.
So let's say if it comes out in the interview that you have committed an immigration offence or a customs offence or a drug offence, or criminal damage, for example, at the bottom there, the interviewer can deduct from a range, is that right?
Yes.
So is there any guidance given to how many points to deduct? Or is it just left to the interviewer to decide?
Well, there's a range that if you look under the points, there's a range from 0 to 20 or 30. And it depends on the offense, the seriousness of it. So that information, once the information is received from the relevant authorities, it is looked at, to see the seriousness of the offense, and therefore a decision is made as to how many points should be deducted. So
it's not a decision made by the interviewer filling in this form. Is there further discussion?
Depending on the matter, yes, further discussion with myself as a chief immigration officer could be taken on a situation like this. And
as this process, I mean, you said that you will get information. So will you actually sort of do some drilling down to find out what the person did, what sentence they got, how serious it was? It's not just simply, right, on their police record, it says that they committed an act of criminal damage, they lose 10 points. Part of the process is that you actually look deeper and try and find out more information, is it?
Yes, Exactly.
I see. So you will look at, for example, I mean, somebody who gets sentenced to prison may be deducted more points than someone who doesn't.
Yes.
If people have spent convictions, are they obliged to disclose them to you?
Yes.
How does I mean the point system is really to in some part to identify whether the conditions set out in section 16 are satisfied. For example, the intention of making the territory one's home, that intention is a real intention. So some of this goes to that, such as the cultural questionnaire and so on. But how does this deducting points in what's essentially an assessment exercise, a broader assessment exercise, fit together with the condition in section 16, precondition in section 16, for most categories of the applicant being of good character? That's a precondition. It's nothing to do with putting it into a pot to make a general assessment. If an individual is not of good character, that's that. That's the end of that, because it's a precondition.
Commissioner, if I may, I think first and foremost, there is the assumption under the provision of the determination of good character that there has to be a reasonable way of assessing such, and on the strength of application and the interview, that the way to pry this information would be a combination of sources. So the questionnaire, if you consider it as a questionnaire, of course, there will be the assumption that there will be disclosure of any matters that may in some way adversely conviction as described in this particular schedule, and that there will be some discretion based on severity of the offense, because not all offenses, as we know, are to be treated the same. So my understanding of the schedule of offenses and the range of points is to afford the board, at the time when they're considering that applicant and they're face-to-face, whether you consider that individual electronically, I guess it's a different story, but at least most of the interviews would happen in a live setting. And the nature of the dialogue would be more dynamic than, say, the disclosure of any offense. So I guess that some discretion will have to be applied.
But, well, I mean, it depends what you mean by discretion, Mr. Smith-Abbott. That an individual is of good character, no discretion. It's a condition of the statute. What good character amounts to, that may involve some form of assessment.
Well, this would be the way in which, as I understand it to be, this would be the way of assessing good character to some extent.
But Mr. Penn says that said that the points system is what matters is the cumulative score at the bottom, and therefore, if you hit the top in severity of offences, other than two which are referred to Chief Immigration Officer, which is homicide and drugs offences, leaving those aside. If you hit the most severe offence in any other category, which might well undermine what you having a good character, but that simply goes into an assessment, and it can be overcome by money or income, the cultural questionnaire, and so on, other things. So how does the assessment of good character take place? I mean, there must be written guidelines.
To answer that, Commissioner, I would say that although there are deductible points for offences, This should be taken seriously. Although I stated, there's a cumulative points to be added. This in itself, if someone committed an offense here, despite the points that are here, and despite the cumulative points, someone good character will come into question, even though there are points here, it would mean that that their good character might be out of the window, and therefore they could be disqualified based on that.
And how in terms of the process is that done? We're now at the process. Mr. Roberts taken us through the interview and the question and the form that we've seen, but how is that taken into account? How is the assessment of good character done?
Well, as I said before, all applicants have to submit a police record, a local one that is, and that is looked at to see if they have any pending matters, if they had any pending matters before, and then more investigation is made, and depending on the seriousness of, and depending on what it is,
Of course.
Because I mean, there are some offenses here, customs offenses, immigration offenses. There could be other offenses, that are not here, because most of the other offenses that are here are very serious. There could be traffic offenses, other offenses, but
who makes the assessment that somebody is of good character for the purposes of, for example, section 16(3)(a)? It's a precondition of subsection 3. You've got to be of good character. Who says, well, look, I've looked at his record, I've looked at this, that, and the other, and this man satisfies that condition. It may be that he's got some convictions, but I'm satisfied that he's of good character, and therefore he can go forward into the process.
The board makes that recommendation. The board makes that recommendation. So even if someone has applied and has a questionable character, it still comes before the board.
Right.
Okay, and therefore, if the board decides that it should go ahead, then they would put recommended. If they think that the character of the persons is such that that it shouldn't go forward, then they will put not recommended.
So you, as it were, gather the information of the criminal record and so on. You put that to the board, and then the board decide whether the individual is of good character and whether the matter should then go forward as a recommendation or not.
Yes.
Thank you. Thank you very much, Mr. Bennett.
So what we have, Mr. Penn, as we've been going through, there's a number of steps. So the first step is, I'll call it the review step. That's where the immigration department looks at the application form, decides whether all relevant documents have been submitted, which can include a police record. There's then the interview stage, which involves sitting the cultural test, having an interview where the interviewer will have the point system form in front and will be completing it, and you then end up with a mark. Now, I think the total mark on the points system is 150, isn't it? That's the highest you can get.
Yes.
And I think 50% is described in the affidavit as desirable.
Yes.
But there's not a cutoff, is there?
There's not
a cutoff. It's not a point of if you don't score 75, you will not get recommended. It may be harder to get recommended, but
yes, it may be harder to get recommended.
It's still possible.
Well, with it depends on the circumstances. Let me put it that way.
And just before I leave the form entirely, the last part of it is it's just a box that says surveillance. What's the reference to surveillance about?
Which boxes?
It's page 1573.
Yes, as I said before, the surveillance department within the surveillance unit within the immigration department, they were part of this interview process at one point, but because of manpower, this was temporarily discontinued. So what surveillance would do, they would more, be there in the interview, who would, look at all the applicants and get background on all the applicants and look at their police records. And if there was any offenses on the police records, then they would, get all the information necessary or relevant, for this interview.
I'm going to leave the form, but the other question is, I mean, you've got an interviewer seeing this, but how do you ensure consistency of marking across applications? I mean, if we take your example, if we take criminal offences example, let's say someone discloses a traffic offence. It's possibly not the best example because there's not one on your list, but somebody may take a view that only deserves deducting 10 points. Somebody else might take a view that actually deserves much more, 20 points. Is there a system whereby you ensure that there is consistency of marking so that you don't get variability because of the interviewer's own bias?
Well, I wouldn't say here today that the marking of the the system is one that is outlined and has all its parameters that someone can follow. And but I would say that if an offense of a traffic violation and a deduction of 3 or 5 points is done, then if a traffic violation comes up on another application, then the same is applied. So I'll put it that way. In terms of other offenses that are here, again, even though there's 2 that says refer to the chief immigration officer, most of these that are listed here, most times they are referred to myself for an opinion as to how many points should be deducted.
If we look at the bottom of the form 1573, it records that the total points available, and this is the current form, is 150. Then says deductible points for failure to assimilate and also for criminal convictions, and then concludes applicants should obtain at least 50% of points from areas which are applicable to them for application to be considered further. So that suggests that if they don't get 50%, they're not going to get recommended. But if you go to 1339, at subparagraph E, it refers to the total of 150 points. It describes the score, and this is Mr. Smith-Abbott's affidavit, the score of 75, which is 50%, as desirable for tenure applications. It notes that the internal auditor's evidence was that an applicant had to achieve 50% marks on all areas applicable in order for the board to make a positive recommendation to cabinet, but then says the board is not now so confined in the recommendations it might make. And later it says that the board does consider low scores carefully and gives reasons that might amount to mitigation, an explanation of why a low score might have been achieved, and then concludes the detailed minutes of board discussions would show deliberations on such cases. I just want to understand the actual policy approach at the moment, because your form says if you're 50%, if you don't make 50%, that you're not going to get further. But the board, and we'll look at how the board works in a moment, but it appears to be that the board can still recommend even if there's a low score.
Well, to answer that, I would say again, you would judge those cases on a case-by-case basis, and there can be some exceptional cases that could fall within those areas. I wouldn't presume at this point in time to give an example, but I would just say that that there could be a few cases that could fall within that exceptional below the 50% mark.
So you would describe someone who gets below 50%. I mean, they'd have to show or the board would have to find an exceptional case to justify making a recommendation where you're below 50%.
Yes.
But is there written guidance or criteria which the board apply when they're considering recommendations or making recommendations, or do they just take each applicant in turn and consider the circumstances?
Yes, they take each applicant in turn. The board would look at the scores that the applicant would get on every category, and they would look at all other matters that are there on the profile, and then make a determination. So it's not a blanket recommendation. When an application comes before the board meets, and they would discuss each application in turn.
So simply because an applicant had fallen below the 50% isn't necessarily a knockout blow, but similarly, I assume that just because he or she is over 50% doesn't necessarily mean that the application is going to be successful.
Right. So as I said, there could be some exceptional cases, that the board will take interest into, and then make that determination.
Yes.
And I think we're now back at the affidavit. If we go to page 1343. 1343, which sets out the role of the board. At paragraph 24. So once you've gone through the interview process, and as I understand it, page 1343, it's just the very bottom. In terms of additional guidance, there will be guidance on how to conduct an interview. There will be guidance on what questions to ask in the interview, but that's it. And then does the whole file then go to the board, including the cultural test score and the point system score?
Yes.
Are there ever instances though when the applicant, the point system is not applied to an applicant?
No, I don't know of any such cases.
If you look up in the first bundle, if you go to page 475, please. This is a memorandum to Cabinet, which is dated 18th of February 2015. Please don't mention any names, but if we go over to 476 and you look under summary of recommendations at number 6, it refers to 2 applicants who scored below the minimum points attainable due to unemployment and retirement respectively, and therefore the point system could not be fully applied. If you then go through to 487, the bundle. Sorry. Please, Mr. Penn. Sorry, if you go to 562, please. If you go through to 564, there's a reference there, and this is a application from June 2019. But there's a reference there to, on 564, to 7 persons scoring below the minimum points attainable in the point system, primarily because 2 were attending university and not employed, other persons who were not employed, and the point is made, reference is made to businesses being affected because of the 2017 hurricanes. It notes that everyone who holds certificates of residence have contributed to the territory over the years. And now this may be a sort of wording in memoranda, and you're not responsible for those, but it's either that it suggests that exemptions are available from the point system, either wholly or partially. Is that how it works, or do those notes reflect later deliberations by the board?
Yes, that's how it works. As I've said all along, it works on a case-by-case basis, depending on the circumstances, and therefore those decisions are made made in terms of recommendation by the board. So this information would go to Cabinet from the recommendation by the board with those notes to Cabinet, where Cabinet would be informed of all this information, and therefore Cabinet in their discretion would make a determination whether to grant or not.
I mean, let me give you one more example. It's at 472 in the same bundle, which is a Cabinet paper from December 2014. At 5, it notes in relation to 3 applicants that they were out of the territory and were exempted from evaluation under the point system. And in relation to another 2, it notes that the point system was not fully applied because these ladies are retirees. And in relation to a 3rd, it was recommended that although the person scored below the minimum points obtainable under the board's evaluation system, the person was recommended because of the person's spouse's support for the application. So when we get to the board stage, when the board is considering matters, the board has, in reality, in practice, has discretion to almost start all over again, because you can have situations, it seems, where people score below the minimum point, but the board still recommends. Or, as we've seen in one example, you have some people who were not evaluated under the point system, but still got recommended. Is that how it works in reality?
There can be some circumstances like that. There can also be circumstances where the board does not recommend, but when it goes to cabinet, then cabinet would, would recommend. Sorry, would approve.
But these are cases, we've seen 3 instances where the points gained were below 50%, or I think in a couple of cases that the point system simply didn't apply because the individuals weren't residents at all. But nevertheless, the board recommended them for belongership, presumably just taking everything they had into account that was before them. I mean, including obviously the number of points that were scored.
Right. Again, I can only go back to the circumstances at the point in time. There could have been a number of mitigating circumstances that the board would have seen in such cases, and therefore would make such recommendation.
And in the minutes of the cabinet meeting, the board's reason is set out. I mean, for example, an individual retired or a full-time student or something, very
Right.
briefly, but I mean, the core point is at least set out.
Yes.
So and what the board will have when it's considering the application will be and I think you sit on the board as Chief Immigration Officer, do you not?
Yes, I do.
But you will have the application form and all the documents. You'll have the result of the cultural test. You will have the result of the point system and the interview. And it's on that the board then makes its decision.
Yes.
And do you see the board, as a member of the board, do you see yourself having a discretion to recommend or not to recommend?
As a member of the board, I do not have a voting right. I'm just an ex officio member.
Yes, fair point.
And so I do not vote on the recommendations.
But it doesn't work on the basis of the board going up. They scored 74. This we're not recommending. They will look at everything.
Yes.
And once that's the board has made or reached a view about recommendation, that then gets put into a cabinet paper, and it's then sent to cabinet for a final decision. Is that right?
Yes.
And what is provided to cabinet? You've spoken of sort of a profile that's put together. Is that what's provided to cabinet, or does cabinet get provided with all of the information?
They get provided with a profile and other information.
So everything that the board has seen, cabinet can see.
Yes.
And as you said, there are instances when cabinet will not accept the view of the board.
Yes.
But I think more often than not, cabinet does adopt the recommendation that's put to it.
Yes.
Going through this process now, so we've taken it to cabinet at least, but is it possible for, I think we can look at this at page 1341 at paragraph 17.1, Mr. Smith-Abbott writes, it's not possible for an applicant to obtain belonger status other than by the procedure I have described therein. So there is, that is now the established process and has been for a significant period of time, Mr. Smith-Abbott?
That is correct.
You point out that at 17.4, where you refer to the Internal Auditor's Report of 2012 and the evidence that, or in that report, that in 2011, 224 people received belonger status from cabinet, without going through that process. So those people were able to, or those applications sidestepped the process of making an application, it had being reviewed by the Immigration Department, being considered by the board, who then make a recommendation. It went straight to cabinet. But you conclude that we are aware of the need to ensure that such situations do not recur, and we make every effort to see that they do not. I mean, what safeguards can you put in place?
Well, I think that the assessment undertaken by the internal auditor, coupled with the discovery of this particular incident, will lend itself to ensure that moving forward, there is a process, even if cabinet, for instance, is minded to recommend directly that the application and the vetting of that individual or individuals would still have to be a precedent in order to make a determination. So that effectively becomes at least a possible guideline that can be afforded to cabinet should it be minded to make a recommendation of that nature. In other words, identify a worthy person who may have not made an application. So therefore, that becomes an individual who has to go through this process that the chief immigration officer would have described, including the vetting of that individual at the immigration board level in the manner just described. So it does not necessarily mean that that individual immediately is approved or disapproved. It just simply means that some of what we will need to provide by way of guidelines and advice to cabinet will be that, yes, you can be minded to make such a recommendation, but if you're going to do so, there is a process that must be undertaken, and the process already has been described.
But what happened in 2011 was that cabinet just granted. So there were certain applications that had gone through the process, been vetted, been assessed, but on top of that, cabinet just granted belonger status to a number of people. And the risk that brings is that you not only are granting belonger status without somebody going through the process that others are expected to undertake, but you may be granting belonger status without going through the mandated process on statute. So, for example, the requirement for consultation with the board that appears under some limbs of Section 16. But how is it, ultimately it's for cabinet not to do that, isn't it?
Yes, but it is for the ministry to define a process, taking on board the internal auditor's recommendations to ensure that there is published guidelines. There are published guidelines that will speak to such consideration. So therefore, when I say that there is a need to ensure that such situations do not recur and that we make every effort to see that they do not, that places a burden on the ministry to define that particular path, so to speak, if we're going to call it that. So therefore, it requires that the ministry disclose the way in which such an applicant, if you want to call it that for the moment, can reasonably be considered. And what I am suggesting in no certain terms is that the process that the chief immigration would have described would need to be clearly articulated. It's not to say that they cannot consider it, but there must be consideration after some due care and due diligence, as any other applicant would have. So I cannot say anything about what happened in 2011.
Of course.
What I can say is that, and I cannot say that any cabinet may be minded to repeat that, but what I can immediately say is that, again, based on the lessons learned, so to speak, and the assessment by the internal auditor, that it again places a burden on the ministry to be extremely clear about the manner in which something like this can happen.
I mean, there are two steps on the Mr. Smith-Abbott. One is the setting up of a scheme, a process, which is open and transparent for all applications, and Mr. Penn's taken us through that scheme. And secondly, because they all have to go up to, once we've got the recommendations from the board, they go to the cabinet, who make the final decision on the applications. It's also incumbent on the cabinet not to bypass that scheme.
Correct, yes. So therefore, as a response, it would be reasonable to suggest that the point system effectively becomes a good basis for disclosing exactly how this process is to be undertaken, right? There is no reason why we cannot, as a matter of immediate action, take the due care and concern and the due diligence expressed in this point system and make it public, make it a document that is palatable in terms of the disclosure of the guidelines for the due care and consideration that will be exercised and by the department in its administrative functions, and certainly the board in its consideration. It would generate some interest in the public sphere, because of course, at least there will be a public disclosure of the notwithstanding this process that we're undergoing right now, but moving forward, it would be reasonable to say that we will take this point system, transfer it into some kind of, what do you call it, a policy, a guideline, or whatever the case may be, as a means of disclosing that this is what the board looks to in considering an application. And furthermore, an applicant could be minded to assess these guidelines that are clearly stated here, notwithstanding the fact that we've had some discussion about whether points can or should be ascribed based on some discretion. That's not really the point at hand. The point is that the belonger, what we're calling the point system, is a belonger status and resident status assessment. So that means that this becomes the benchmark, the guideline, beyond just simply stating that 20 years becomes the benchmark. That is really absolutely not the case in a functional, practical way. It's just that simply we've not published it. So this now becomes, in our minds, a means of addressing this whole question of disclosure in terms of good governance and the transparency that will be required of us with respect to how.
So in relation to the scheme, the point system, I think what you said amounts to this, that the system is not perfect and it may be capable of improvement, but basically the point system is sound. It should be published so that applicants and everyone else knows the basis upon which the scheme is processed. But that's step one. Publish the guidance. But secondly, it's also important, isn't it, to maintain the integrity of the scheme, that nothing is done to bypass the scheme. So we know that in 2011, for one reason or another, applicants were simply drawn in by cabinet outside the consideration of the board at that time of other applicants. Individuals simply taken and given belonger status, bypassing the scheme that was then in place. And so to maintain the integrity of the scheme, it's important that it is not bypassed in that sort of way.
Yes, I know that there is a, in terms of basic principle of good governance in considering applications, we will want to ensure that equity and fairness is maintained. So there is, of course, a whole question of whether it's equitable and fair for someone to be considered over, say, another person who may have gone through the extensive due diligence process just described by the chief immigration officer. And that, I think, can become a value that can be articulated clearly in any guidance for internal or external consideration.
I mean, as you say, it may be a question of fairness as between those who've gone through the system and those who haven't. But in terms of transparency and openness, simply to bring some people in outside the careful point system and allow them to have belonger status without any published or known criteria, it's sort of more than just unfair. It's not good governance. It would not be good governance.
I agree.
We're talking hypothetically, but it would not be good
But
governance.
I agree. And I think that, again, it places the burden on the ministry to ensure that in the guidance provided, whether it's externally driven, and by that I mean published to the public, or internally.
And like, I was going to say all, but I'll certainly say most circumstances in which there is poor governance, because governance is intended to reduce the scope for dishonesty and corruption in public office. By not having good governance in place, it at least increases the risk of such dishonesty. Because if somebody goes through this scheme and comes out, and I appreciate there are some assessments involved by the board and ultimately by the cabinet, but good governance in respect of that scheme reduces the scope for dishonesty and corruption, because that's what governance is all about.
Agreed, and I think the clear statement here to be made is that first, there is a process, perhaps not necessarily immediately disclosed prior to this point, but there is a process. Those individuals who would have gone through that process would have generally been aware of this. And we will build based on the assessment of the process as it stands. I mean, any process obviously can benefit from oversight and review. That could obviously start with the inputs received from the internal auditor all the way across to this particular process. It's a continuum. And that will certainly then inform the way in which the ministry can structure the guidelines and the published policy, as the case may be. It could certainly inform the nature of the consultancy to be undertaken, as disclosed and described in the affidavit, and we're now talking through these issues. So there are several inputs, I think, that would be valuable to take into consideration when defining what an immigration policy at the broadest level. I've already made reference, of course, to some of the other inputs received from the public during the fast track period. All of these things will have to be looked at carefully. And I think that it is also reasonable to suggest that there are two steps to be pursued. I think that first and foremost, as a matter of priority and urgency, we will want to consider the publication of the point system as a means of at least disclosing to the public how those applications are considered. And then, of course, there's a much broader exercise to be undertaken under the consultancy without prejudice.
Yes. Thank you, Mr. Smith-Abbott. Is that a good time to break, Mr.?
Yes, we can do it now. It's fine. Thank you.
And this may be a difficult question, but I'm just thinking about the honourable minister who's coming.
I've suggested to those who sit behind me that we might alert the Honourable Wheatley that perhaps he should come at 3.
Yes. Well, I think that's probably good. So we'll come back at 2 o'clock if we may, Mr. Penn, Mr. Smith-Abbott, and finish off your evidence, hopefully by about 3 o'clock, and then we'll have evidence from the Minister. Good, thank you very much. Good, thank you, Mr. Rawat.
Thank you, Commissioner. Gentlemen, welcome back and thank you for returning. Commissioner, just for the purposes of the transcript, can I just note that in terms of legal representatives appearing on behalf of the participants, there are none who appear to be attending for this afternoon's session. Could I ask, I think it might be Mr. Smith-Abbott, I'm hoping might be able to help with this, but if you just turn up paragraph 26 of the affidavit, please, which is in part 2 of the bundle. And it's at page 1345.
Excuse me, may I be given the paragraph number, please?
26, please. Are you there, Mr. Smith-Abbott?
Yes, I am, thank you.
At paragraph 26, and this arose in the letter of request to Honourable Wheatley for an affidavit, but the point is made that in evidence that Dr. Orlando Smith gave to the commissioner at an earlier hearing, the suggestion arose that an applicant should be granted or could be granted. So I'm going to start this again. The suggestion arose that cabinet members could suggest that an applicant be granted belongship status, but the ultimate decision was for the immigration board. The point that the affidavit makes is, and it begins with great respect to the former Premier Dr. Smith, but the point is made that it is for the board to make representation and cabinet to make decisions. And that in the last 5 years, no persons have received belonger status based on a recommendation by cabinet. Persons have done so pursuant to decisions of cabinet. But the point can be put in a different way because it goes to whether a minister can intervene in a process. And so could you have a situation whereby a minister could approach the appropriate officer and say, I think that this person is suitable for belongership and should be the subject of recommendation? And the extension could be made. Could you have an intervention from a member of the House of Assembly on behalf of a constituent saying, well, this person ought to be recommended for belongship status? And taking those two scenarios into account, it goes back to the point that you were discussing with the Commissioner before the break, and that is the robustness of the system that you have in place. How does the system account for potential interventions from, for example, a minister or a member of the House of Assembly?
So just to recall the process, the individual will need to make an application. There will be the collation of information that will comprise the material then to be considered by the board. The board would undertake whatever due diligence which we've described and make a recommendation. Therefore, in your hypothetical scenario, it will require that that member not only influence perhaps the administrative branch, but then also the board in the discharge of its functions. I can't say under what conditions that may happen or whether it can or cannot happen. What I, what I can say is that, as you pointed out, the robustness of what we have right now would indicate that it would be somewhat difficult, not impossible, I guess, but difficult to influence several entities all at once to then derive a decision at the level of cabinet in favor of that individual. So going back to the point that the Commissioner inquired about in 2011, cabinet would need to, quote, bypass that process of due diligence, so to speak, to result in the disposition, perhaps a favorable disposition of an individual to be granted belongership.
Or override it. So
Override it, yes.
yes.
But to suggest that a member would be able to influence the various levels of due diligence, not impossible. It would be something to consider, I guess.
It can be put in this way, because I mean, you can see from the events of 2011 that Cabinet could simply make a decision outside the process. Cabinet within the process can reject or accept recommendations made by the board. But this is more, but not necessarily, it's not necessarily, it's not about the outcome. It's not about whether the board makes a recommendation when, in absent the intervention, it would not have. It's about, even if it's an attempt to influence the process by a minister or a member of the House of Assembly intervening in the process in the hope of influencing an outcome. And the question is, you have a system that tells people these are the documents that you need to submit. You then have a paper process that ultimately leads to a face-to-face interview, and then leads to the board meeting to consider all of the material. And Mr. Penn has explained the circumstances of that. So it's about, my question goes to the idea that you have a process and then somebody from outside tries to move that process in a particular direction. And my question then goes to the design of the system. How is the system set up to deter any attempt at influence?
What I can say is that the process as described by the Chief Immigration Officer is such that you would almost have to influence several levels and individuals all at once to determine the outcome, which would be a recommendation, because effectively, and this is a very hypothetical question, which I'm not sure I can reasonably answer any other way than to say that in order for, if a member of the House of Assembly has a conversation with a particular board member, and that board member then tries to sway the outcome, we would not be able to, I can't say anything more than that. The system is designed, as described, to have vetting process administratively undertaken by the department with the collation of all of the required documentation to support a recommendation that the board, after undertaking the due diligence required under the procedures that have been outlined, will then have something to say about whether an applicant is worthy to be recommended for or against. And what we will then want to very clearly suggest, and which I have already said, is that there will be another layer of transparency in the process by the publication of say, the point system, the assessment process, so that individuals would know beforehand what can be expected of them in considering their applications. Will they then want to use other means of influencing the process? I can't say that, but I think that, again, the burden of what is imposed on us as the ministry is to ensure that we can reduce the likelihood of undue influence, if you want to call it that.
Or an attempt at
An
undue.
attempt, insofar as that already set out beyond what the Chief Immigration Officer has stated, other measures that we will undertake to.
Do you currently have written guidance available to officers and to board members about what they should do if faced with an attempt to unduly influence them in a certain direction?
Not at present, but I think that if we look at guidance which has been produced for other boards, for instance, and I can again recall an earlier testimony regarding, say, the National Parks Trust, the Social Security Board, with their own operational guidelines, and especially conflict of interest or undue pressure being applied to the board to have a particular outcome on an application. Again, that becomes the material that can reasonably be used to craft operational guidelines for how the immigration board to conduct that exercise, which would have nothing to do per se with the procedures as described. It's reasonable to suggest, and point is taken, that we can, as any board would be minded to do, to operate under guidelines that reduce the risk of undue influence in its decision making.
Thank you. If I move on to a different topic, and if you actually stay on the same page, but just look above, it's right, isn't it, that the present position, and it's one that has attained for a significant period of time, is that Cabinet does not give reasons when it refuses or rejects a recommendation from the board.
Repeat that.
Of course. We've seen the outcomes of Cabinet decisions where Cabinet accepts recommendations, but there are occasions when it rejects a recommendation from the board. And it's right that at the moment, it doesn't actually give reasons when it does so.
Right.
Because paragraph 25.9, the affidavit notes, and it's right at the end of the paragraph, the board does record its decisions. And it says, as I have described above, and I'll pause there, and that the board will produce minutes in which it will have recorded the basis on which it makes a recommendation. And correct me if I'm wrong, Mr. Smith-Abbott, but that will also inform, therefore, the Cabinet paper
That is correct.
provided to Cabinet. But it then continues, I agree with the recommendation with regard to Cabinet, especially if Cabinet does not follow the recommendation of the board, and that is a recommendation that Cabinet should give reasons. And it seems that you would say, at least from the perspective of public officers, that it's a good idea for Cabinet to give its reasons when it rejects a recommendation from the board.
Well, we can certainly recommend that in determining a particular outcome with respect to an application, that applicant be given a reason. We can certainly recommend that Cabinet be minded to advise that applicant as to why it was rejected. Perhaps there may be good solid reasons to do so, and just for the benefit of transparency, it may be in good order.
Now, in the same section, it's at page 1344. That's the portion of the affidavit that's discussing the role of Cabinet in the process. And the point is made that Cabinet will make the final decision, and in doing so can receive further advice. And if we take, and you give the example, you give an example there of such further advice, very recent. And if we turn that up, it's at page 1733 in this bundle. It's a Cabinet memorandum dated the 5th of February 2021 in relation to applications for certificates of belonging status. And before I move to the point that I want to take you to, gentlemen, Commissioner, if I just point out, you'll note that at the end of the first paragraph, there's reference to Cabinet having moved away from the capped number of approvals per year, which is a point that's made in the affidavit. Now, in this case, if we go to page 1735, the purpose of the paper is recorded at the top, paragraph 6, as to allow persons who are married to BVI Islanders or belongers for a period of over 5 years, or who have resided in the territory for 25 years consecutively, to be granted belonger status. And the legal advice that is given comes from the Attorney General. And if we begin at paragraph 10, the Attorney General says, insofar as the decision sought at paragraph C is concerned, and if we want to see what that decision is, we can turn up page 1737, which is to accept the recommendations of the Board of Immigration to grant certificates to 21 individuals who, in the opinion of the board, have met each of the legal requirements under section 16. So these are applications for belongership by tenure. And to return to 1735, the Attorney General advises is that in addition, with consultation with the board, pursuant to section 16 of the Act, Cabinet must also consider the following in deciding whether to grant a certificate. And then it sets out the various sections of 16.8. Now, dealing with this, I mean, the Act sets out that in relation to certain provisions, Cabinet must consult with the board. What is the consultation process that Cabinet engages in?
If a recommendation goes before Cabinet and Cabinet is not in possession of or is not entirely convinced that they don't have enough information or would require more information, then they would consult with the board in order to get that information to make a determination.
But it's not routine for a Cabinet in relation to every application to consult with the board.
No, it's not.
So the Cabinet will rely on the material that the board puts in front of it.
Yes.
Have you ever, as Chief Immigration Officer, been asked to attend in relation to belongership applications, attend a meeting of Cabinet?
No.
Permanent Secretary, have you ever, in the time since you've been Permanent Secretary, have you ever been asked to attend? To respond in relation to belongership applications?
I don't believe any applications have been considered during my tenure, but
what it makes clear that this section that we looked at, and this is a memorandum that the affidavit draws the Commissioner's attention to, is that in its approach, Cabinet has to consider the section 16.8 criteria, certainly when it comes to section 16.3 applications. That's right, isn't it?
that is correct.
In going back to the affidavit, what...
Can you please give
yes, please go back to 1344, please. Um, 25.4, what's said is that Cabinet will balance any loss of revenue in approving applications with the potential economic benefits of more closely integrating the applicants in the community. And the example is given of the fourth generation applicants. Just clarify or expand a little, please, on what's meant by balancing any loss of revenue against potential economic benefits.
So as I understand it, some of these individuals would be subject to immigration control, would be subject to having work permits, as the case may be. So that represents potentially revenue, which would be offset by, say, the other benefits as described, economic activity generated by that individual or individuals that will offset the direct revenue into government, say.
And is that part of the subparagraph A of 16.8? So, sorry, I'll start again. Subsection 16.8, subparagraph A, speaks of the economic situation in the territory as one of the factors that the Cabinet has to consider. Is that where this consideration of the balance of loss of revenue against potential economic benefit comes into play?
If I'm understanding the question correctly, which is how do you consider economic benefits in this context? Is that more or less what you are asking about? Or?
Let's take you to the Act quickly. If you go to 1439. That should take us to section 16, subsection 8. And subsection 8 reads, in deciding whether a certificate should be granted pursuant to subsection 2A or B, in respect of any applicant, the Cabinet shall consider whether A, the economic situation in the territory is such that the grant of a certificate to the applicant will prejudice the protection afforded under this Act to other persons engaging in the trade or profession in which the applicant is engaged or in which he is likely to engage. And then the other factors are close personal connection, character and previous conduct, and continued residence and association with the territory may afford some advantage. And it was A that I was drawing to your attention to. So where the affidavit speaks of Cabinet balancing loss of revenue and approving an application against the potential economic benefit of that flows from granting the application, does that balance come under section 16.8A?
Well, the balance in 16.8A, I would say, is much, much broader than what I'm suggesting by way of the immediate economic loss of, say, a very narrow source of revenue into government directly. Because this section speaks to the broader economic situation within the territory and an assessment of how the assimilation of these individuals may favorably or adversely impact existing persons engaging in the trade or professions in which the applicant is engaged. So this speaks to a much, much broader context than what you would say is loss of revenue, because to the extent to which now we're looking at, say, an individual who is going into a particular trade. I'm not going to characterize what trade. And he or she may compete and may adversely impact the existing business as it stands. That has to be weighed, that has to be considered, and that's what I would suggest is the intent and the spirit of that subsection, not necessarily just the loss of revenue, because as I would have stated in a few moments ago, the loss of revenue under those circumstances described now speak to sector-based losses of revenue impacting existing trade or professions.
But 8A is clearly, as you described, it's the Cabinet have to consider whether the applicant, whether the grant to the applicant will result in persons in his or her trade or profession finding it more difficult to engage because of the competition.
Correct.
So that's in that sense quite narrow. But what you said is balance any loss of revenue in approving the applications with the potential economic benefits of more closely integrating the applicants in the community. That's a completely different thing.
Yes, I recognize that. And so I think that when we are speaking about belongership as a concept and as a construct is extremely complex. and depending on scale of what you're actually, at what scale are you considering that economic adverse or beneficial impact, you can get into a situation where we are looking at, say, as I intimated initially, loss of revenue directly to, say, government in the form of permits and licenses that that individual may have to secure, against also a much broader societal scale of issues with respect to the integration of these individuals, whoever they may be in whatever sector that they may find themselves, or profession that they may find themselves in, competing against. So ultimately, I think that what I would like to say about all of this is that Cabinet will need to be minded, of course, that all of these scales of impact will have to be weighed. The affidavit may have just simply specifically narrowed that question to one scale, but there has to also be a recognition that it's a much more dynamic and complex situation when considering economic benefit across varying sectors.
But what it points to, your paragraph 25.4 points to, is that in addition to the matters set out at 16.8 that we've looked at, there is an additional factor that Cabinet will take into account: the balance, loss of revenue versus potential economic benefit that's been identified in the affidavit. So that's one more factor for Cabinet to take into account. But are there any others that Cabinet takes into account?
I would refer that matter to the Chief, because I'm not aware of any others, but you may be.
Well, I won't really be able to answer that fully as well too, because I don't sit in Cabinet's deliberations, so
That's fair enough. Yes.
So they make the decision based on the information before them and the criteria set out in the Act.
I see. So as far as your understanding goes, Mr. Penn, as Chief Immigration Officer, I totally accept you're not in the room when Cabinet is making these decisions. But your understanding has been that they look at the information, they look at they essentially apply the Act, and then they make a decision. And that decision might be to agree with the board, or it might be to reject the board, or it actually might be to ask for more information.
Yes.
I mean, the factors in section 16.8 are mandatory. Those are factors which the Cabinet have to take into account, because that's what the statute said.
Yes.
Over and above those factors, is there any policy, written or indeed unwritten, that the Cabinet use in respect of factors other than those four that they look at when they're considering an application?
I wouldn't be able to answer that.
No, I mean, you don't know of any,
No.
but you may not know of any, even if they exist.
No.
No, I understand that. Thank you.
Thank you. What the affidavit goes on to say, and that and it exhibits a number of Cabinet memoranda and decision, which we don't need to look at, but the Cabinet usually follows the recommendations. But when we go back to 1345, the affidavit at 25.8 says there are earlier examples where Cabinet does not appear to have followed recommendations that were given. And if we look at those, if we turn up 1580, this is a Cabinet extract. So it's a record of the Cabinet's decision. It's dated the 20th of April, 2011, but relates, I think, to a decision that was made by Cabinet on the 13th of April, 2011. And what's noted, and I won't read the names for obvious reasons, but that Cabinet had noted the Attorney General's advice in respect of section 16 and added the names of eligible persons to the list for belonger status as follows. And then on the next page, Cabinet then approved the granting of belonger status to a number of persons listed. So that was an example of where Cabinet was, of its own volition, adding names to the list.
That is correct. And earlier evidence provided, because this is the 2011 event that was highlighted prior to our break, that these names would not have undergone, these individuals would not have undergone the processes that the Chief Immigration Officer would have outlined in his evidence, but that they were added at the time when Cabinet sat on the 13th of April, 2011.
And if we go quickly to 1596. Expedited extract sent on the 1st of May 2015 in relation to, I think, a Cabinet decision on the, I think, well, it must be on that day, but certainly May 2015. But we see at A that Cabinet reviewed a list of 5 persons who were not recommended by the Board of Immigration for a grant of belonger status, in accordance with Section 16, and that was on the basis they scored below the minimum of attainable points on the point system. And then Cabinet decided not to accept the recommendations, but approved of the board, which was to refuse the application, but instead approved the grant of certificates to those 5 individuals. So that's an example that your team came up with of where Cabinet was doing the opposite of not adopting, in fact, the board's recommendation, wasn't it?
That is correct. So Cabinet would have exercised its right and discretion to not accept the recommendation of the board and proceed, would have then proceeded to have given the award.
And is it still the practice that all of the applications go to Cabinet? So even those where the board is recommending that the application be refused, that will still go to Cabinet?
So then you.
Yes.
If we turn quickly to 1575 in the bundle. Can you confirm, Mr. Smith-Abbott, this is, I think, a table that which is exhibited to the affidavit, but it sets out the numbers of persons granted belonger status from 2017 to the present. And one can see that there has been, since 2017, an increase in number of applications. But the biggest increases are, or the largest grants were in 2019, where firstly, a tranche of 648 which was belongers only, grants were made. And then it says 541 persons were granted residence and belonger status. So they were granted both in one event, is that right?
Yes, that would have been the fast track.
And so it's the 541 that are the fast track, is that right?
That's correct.
So the 648 would have gone through the normal process?
These 648, as I understand it, and again, the chief is here with me, but the 648 were likely residents who would have then applied at that time to become belongers. So again, understanding that really and truly we at that particular time, you're addressing 2 groups. Residents who would have already have had some measure of status, so to speak, and who could then apply for belongership under that particular program to be considered, and then the 541, which represents both, is just simply the merging, as earlier stated.
The 2 processes.
Of the 2 processes, yes.
Yes, and I think actually the point made, I mean, certainly between June 2019 and February 2020, the only way you could make an application was through the fast track.
only way that an application would have been made during that particular period would have been under the fast track?
Because the system, the provisions had been changed. So
There would
between
there was
June,
certainly
you didn't
nothing
have
that would
two
have
parallel
prevented-
legislative systems, did you?
there would have been nothing that would have prevented an individual from just normally applying. Fast track was just simply a program designed to address a backlog in that case. But again, there may have been individuals who may have just simply applied in the normal course of having their applications considered. Chief?
Yes, during the fast track process, the law was amended, and that was the law at the time for that period.
So whether you made an application in the normal way, as opposed to the fast track process, you were still being considered under the law at the time.
No, I don't think that's how it operated, because you'd have had two competing laws, because the fast track went to the House. It was made law, so that is the law to follow.
Yes, no, I think we're both making the same point, Mr. Penn. That there was only one law between June 2019
Right.
and the beginning of February 2020, and however you applied, that was the law that applied to your application.
Right.
I mean, I think there's a distinction between the fast track as a process allowed people to pay additional fees, I assume, to have their applications considered
Yes.
more swiftly.
Right.
And I mean, the figures are that in 2019, there were 204 grants of belonger status, either by marriage or through the regular, the pre-fast track scheme. And then there were 1,189 who went through the fast track, 648 on the belongers only part, and 541 on both residents and belongers limbs. That's what this table says. So the 1,393 grants in 2019.
In terms of the standard process, how are applicants informed of the outcome of Cabinet's decision?
Once Cabinet have made a decision, once Cabinet have made a decision, a copy of the extract with the decision is sent to the ministry and then to the department. Once the department receives that, then the department start notifying persons of of their approval, and then letting them know that they would need to come to the department to make payment, and subsequently after that they would be called to receive their certificates and an ID.
And is there a fee to be paid at the beginning of the process if you want to make an application?
No, there's no application fee at this point in time.
So do you pay a fee if you're successful? Or?
Yes.
I see. Just help me with this, though, in terms of understanding the fast track process. So, and how it worked. If you go to page 1347. You've confirmed, Mr. Penn, and we've looked at it, the statutory amendments that were made so that, in effect, for a time-limited period, there was a different law in operation. But I think the points that made in the affidavit is firstly that the ordinary residence test didn't change. Is that right?
There was an amendment to the residence as well, because the I think the 20-year limit was put in there.
Yes, but in terms of what ordinary residence means,
Oh,
that didn't change.
no,
You still had to, there was still a limit on how long you could be outside the BVI.
right.
What was, I think, if we look at, I think it's, you'll see that what the test is, if you need to look it up, is that it's a 10.7 of what ordinary residence means.
$10.7.
Yes, so that did not change. That in effect, depending on the basis on which you were applying, you still, there was still a maximum number of days that you couldn't exceed to be outside the BVI, and also the grounds on which absence would not count against you were still illness, study, government service, or service in the armed forces.
Yes.
And other than that, if you were absent for different reasons, and we've used the round the world trip example, which perhaps, given we're just coming out of a pandemic, isn't the best example, but
No.
it's a non-pandemic example.
Right.
But if you were doing that, then time would still count against you.
Right.
And you set out, if we go back to 33.4. 33.4. That helpfully sets out what the amendments were made to section 16.4 and 16.5. So in relation to 16.4, the big change was, firstly, that the cabinet could decide whether, in the exceptional circumstances of any case or any reason, if cabinet considers it fit to do, it could, in its own discretion, grant a certificate to any person who applies in the prescribed manner and who A, is of good character, B, at the date of making the application, is ordinarily resident in the territory, and C, has been ordinary resident for a period of not less than 7 years immediately prior to his or her application. So that the big change there was that there was no role to be played by the board in the process. Is that right?
Well, according to the changes, it would appear that way.
Right. And then 16.5, which I think Mr. Rockefeller is the only beneficiary of so far. The big difference again was that there was no requirement for an application, and there wasn't a requirement that the person had been ordinarily resident in the territory for a period of at least 20 years. So the policy reasoning behind that, the affidavit deals with at 33.7, and this may be a matter for Mr. Smith-Abbott, but what's said is that with regard to the amendments to subsection 16.4 and 16.5, the government appears to have intended to create a special fast-track process aimed at expatriate workers and those residing in the territory for 20 years or more. So that I think the point was to create a process by which either expatriate workers or those who'd lived in the territory for 20 years or more could combine the residence application and the belonger application.
That is correct, yes.
And if we look at 1663 in the bundle,
One six.
1663, please, Mr. Penn. What's written there? It's a memorandum from the Ministry of Natural Resources, Labour and Immigration, dated the 20th of August 2019, and it's headed application for certificates of belonger status, immigration regularization, batch number 1. And under background information, it refers to the first bill, entitled the Immigration and Passport Amendment Act of 2019. And says this amendment allowed for a special fast-track process to be developed for expatriate workers and those residing in the territory for a period of 20 years or more without gaining status to be able to do so. These persons had the opportunity to apply for residence and belonger status or belonger status only, depending on their pre-existing qualifiers. Paragraph 2 says, the Clear Path to Regularization, Residency and Belonger Status Programme is a special project initiated and driven by the Premier, does not require a deliberation of the Board of Immigration for applications received, but is approved by Cabinet's discretion as stated within the Act. The process specifically requires applicants to submit their application and make payment up front, complete a written exam, and submit all of the same documentation that persons would have originally submitted through the normal process at the Immigration Department. And it then lists the documents that would be provided and refers to a profile being attached for Cabinet's deliberation. Then continues at 3, under this expedited process, a timeline of 3 weeks was allotted to allow persons to submit the required forms and documents. Applicants were required to pay upon submission of all applications a fee of $810. So so there are some differences there between the standard process. So firstly is the Immigration Board is not involved. So presumably there is no interview, there's no cultural test, there's no point system. Is that right, Mr. Penn?
It would appear so.
You then have a short period of time, which, as we've discussed before, was extended. But the other difference is that applicants were required to pay a fee up front for the process. Is that right?
Yeah.
Now, in practice, was the process this, that the applications would still come into the Immigration Department and it would still be for your team to collate the material and review it?
Yes.
But after you had done that, you would prepare the profile and then that would be submitted as part of the Cabinet paper?
Yes.
So we know that from before the board made recommendations. Was the Immigration Department required to make any recommendations?
No.
So it was just still, as you put it, an administrative task.
Yes.
And so the decisions was just down to Cabinet.
Yes.
If you look, please, and we're going back just to the first bundle, please. If you turn up page 724 in that first bundle. Give me a moment, please, Mr. Penn. (724) is another Cabinet memorandum. Again, from Mr. Smith-Abbott's ministry, and it's dated the 5th of December 2019. So, and it's dealing with a batch of applications that need to be put in front of Cabinet. If you look at 726, you'll see under legal implications the comments of the Attorney General, who writes, the size of the number of applicants, in this case 67, and the short notice for comments on the Cabinet paper does not provide me with the requisite opportunity to determine whether or not the applicants have qualified for the grant of resident or belonger status, and that there are no disqualifying factors such as criminal convictions, frauds, etc., whether in or outside the Virgin Islands, which is a relevant consideration in these matters. I proceed on the assumption that the Ministry has conducted the application and that they do in fact qualify under the Immigration and Passport Act for the status that they have applied for. In any event, a certificate granted is subject to revocation for fraud, false representation, or concealment of material fact and imprisonment, amongst other considerations. If you go to 735, you have a memorandum dated the same day, but this is number 444 of 2019, but the previous one was 443. If we turn to 737, the Attorney General again raises a concern there and repeats, this time the size of the applicants is 48. So in one day, 2 cabinet papers had come in submitting just over 100 applications. Now, the Attorney General his chambers was essentially saying that they had not had time to consider the applications. Were those concerns fed back to the Immigration Department?
Not that I could recall.
And in terms of the process that your department had to go through, was it essentially the same as you would do under the standard process?
I can say at that time we had added staff to vet the applications and make sure that everything was in order, including the police records of all applicants. All applicants knew that they had to get police records, and they got their police records. Now, in the absence of knowing whether those police records were were done accurately in that space of time, and making sure that any offenses that they may have had, then it was up to the authorities to make sure that whatever offenses appeared on their police certificate. And if offenses were not there, then if persons are found out, then it would go that they have obtained belonging status by fraud, by submitting a police record, which was not true and correct.
But you've explained the process you go through before in terms of getting the documents in and then checking them.
Yes.
Or you had additional staff this time round.
Yes.
And essentially, was it the same process?
Right, and that was done. Yes.
Now the policy in terms of the policy statement that we looked at from the cabinet paper of August 2019 referred to a written exam being completed. Who oversaw that written exam?
The department itself.
And August 2019, before the pandemic emerged, but were people being asked to come in and sit the exam, or?
Yes.
Right, so everyone had to actually come into the department, sit the written exam.
Yes.
And then that would form part of the material that went to cabinet.
Yes.
Thank you. May I just have one moment, Commissioner? Commissioner, I've reached the end of my questions. Can I conclude by thanking both Mr. Smith-Abbott and Mr. Penn for making themselves available for today, but also not only for the work that has gone into the affidavit, which has been very helpful, but also for the way in which they have given their evidence today. Thank you.
Yes, can I thank you both for your evidence, which has been very helpful in an area which is not always straightforward. So thank you both very much. I think we'll just halt for a few moments.
Yes, and then we'll set up for the next witness.
Yes, please. Thank you. Good. Thank you, Mr. Rowett.
Thank you, Commissioner. Commissioner, before we continue with our next witness, can I confirm for the purpose of the transcript that we are joined by the Solicitor General, Joanne Williams-Roberts, who appears on behalf of the Attorney General and elected ministers. The Solicitor General attends remotely. I should apologise to her because earlier when we started the session, I noted that she wasn't present, but she did join during the course of questions being put to Mr. Penn and Mr. Smith-Abbott. Our next witness is the Honourable Vincent Wheatley. Honourable Wheatley, thank you for returning once again to assist the Commissioner with further evidence. I think you probably know what I'm going to say to you, at least in terms of an introduction. Firstly, of course, no need to take the oath or the affirmation. Second, that you have bundles there to your left, which we might need to look at as we go through. Third, you'll know to speak up, speak slowly, and as slowly as you can, perhaps. But and as I've said to other witnesses, if we end up speaking across each other, I'll stop and I'll let you finish your answer. I notice you've got your laptop with you. What do you have on there, please?
The Immigration Act.
I see. Okay, thank you.
As I assume you're referring to it.
Yes, we may do. The topic on which the Commissioner asks for further assistance from you is that of belongership, and specifically the grant of belongership under Section 16 of the Act. This morning and into this afternoon, the Commissioner heard evidence from your Permanent Secretary, Mr. Joseph Smith-Abbott, together with the Chief Immigration Officer, Mr. Ian Penn. So they have done a great deal of work in assisting the Commissioner in understanding the legislative basis on which belongership is granted, particularly under Section 16, but also the process by which applications for belongership are dealt with within the Ministry by the Immigration Board and then on to Cabinet. As we have learned, in 2019, Cabinet introduced, or the House of Assembly passed, a process which I think we've been calling the fast track process.
Regularization.
Yes, which for a time limited period changed the law and in accordance changed the process. Now, I will ask you some questions in due course about the fast track process, primarily from the perspective of Cabinet, because of course neither Mr. Smith-Abbott nor Mr. Penn could assist the Commissioner once Cabinet convened. So the approach of Cabinet to considering applications is something that we need to ask you about. Now, the first thing to deal with is that you, in July 2021, as Minister for Natural Resources, Labour and Immigration, was sent a letter of request seeking an affidavit which answered various questions on belongership and how the process works. Did you, at the time, see that letter?
Yes, I did. Yes.
And for reasons that Mr. Smith-Abbott has explained, he was delegated to produce the affidavit. And he, in fact, produced two affidavits. One shorter one and a much more detailed one, which, as he explained again, drew on the expertise of colleagues within your ministry, and including Mr. Penn. Can you confirm whether you've seen those affidavits?
I have, yes.
And have you had an opportunity to go through them?
Yes, I have.
Because one thing that can be said is that they do have quite a significant number of exhibits attached. So did you have an opportunity to look at those?
Yes, I did.
Thank you. Now, what followed was a warning letter. And you'll be familiar with that because you have attended to give evidence in response to that when we were dealing with statutory boards. And you should see the warning letter there. I think that's your written response. We'll go to that in a moment. But the warning letter was dated the 15th of September 2021. It is worth explaining once again what it is and what it is not. We call it a warning letter. Historically, it used to be known as a salmon letter, but it might have different meanings in different contexts, in another context, but in the context of an inquiry, its purpose is to alert you to a potential criticism and the evidence on which that is based, and therefore to allow you an opportunity to respond to it. Now, the reason that the warning letter was sent to you is because you are the current Minister with responsibility for immigration matters. And but what we ought to say is that the potential criticism that we put to you arises in the context of a policy that was in existence and in application, I think, long before you assumed office.
Yes, indeed.
But what I should also add is that when I refer to a potential criticism, what I must explain is that such a criticism does not represent either the provisional or concluded view of the Commissioner. The purpose of the letter is to give you an opportunity to respond so that you can be, we can ensure that you are treated fairly. Now, you did indeed respond, and you have prepared a response in writing, which, if I could ask you just to look that up, please, Honourable Wheatley. If you could go to the
It's not bundle.
it's not, it's loose leaf on there. Okay. So it's that
The
document.
response to one, number 2.
Yes.
Okay.
If you go please to the last page. Can you confirm that it's dated the 24th of September 2021?
Yes, it is.
And it carries your signature?
That is correct.
And are you content that that written response should stand as part of the evidence before the Commissioner?
Yes, I do.
That's helpful because it means I can hopefully be a little bit more focused in my questions to you. But let's set out the nature of the criticism. And it is something that we have canvassed with Mr. Smith-Abbott and Mr. Penn today. And that is that in 2004, the Executive Council, as it then was, published and approved a number of administrative guidelines for what was then the Board of Immigration. And those guidelines related to the board's processing of applications for residence and belonger status. And that included that once the backlog, as it then was, had been cleared, the board should make recommendations as applicants reach the 20th anniversary of their arrival in the territory after the normal screening process. Now, the affidavit, as you will recall, the second affidavit that Mr. Smith-Abbott provided on belongership described that 20 years as a benchmark. And the approach that has been taken by government and by public officers since at least 2005, it would appear, is that in considering applications for belonger status, the threshold is 20 years. So after you have had 20 years residence, then your application for belongership will be considered. Now, the Act provides, and we can look at it if you need to, but it provides that you can gain belongership by tenure on the basis of a number of conditions, but this is under section 6.3. But what you have to also show is that you have been ordinarily resident in the territory for a period of not less than 10 years immediately prior to the application. And so what the potential criticism that arises is that the policy that has been applied by Cabinet since its promulgation is one where in adopting that policy, Cabinet has acted unlawfully or acted ultra vires, that is outside the Act, or otherwise because an individual applying for belonger status would have a legitimate expectation that once they had attained 10 years residence in the territory, they could make an application which would be considered in accordance with the Act. And so what's said is that by adhering to the policies it did, Cabinet acted inconsistently with the principles of good governance. Now that's the background, and I've tried to set some of the position where we've reached on the facts from Mr. Smith-Abbott's affidavit to you. So in effect, it would seem that the approach that has been taken is that if someone applies having established ordinary residence of not less than 10 years, and there are other conditions they have to fulfill, for example, they have to be of good character.
Yeah.
But what the effect of what the approach of the Immigration Department would be to essentially put that application on hold until the benchmark had been reached. Now you have dealt with this criticism in your written response, and you make a number of points, please. And I'm going to do it slightly differently from when we did it on the last occasion when we dealt with warning letter number 1 to you. But firstly, if I could, what I'm going to do is just ask you some clarificatory questions, and then I'd like to invite you to just set out your written response to the Commissioner, if I may.
Certainly.
You say that the department typically receives on average 110 applications per annum, and it has limited resources to meet that demand.
Mm-hmm.
First question is, I mean, 110 a year is considerably less than 1 a day. What factors have caused that to have resulted, as it appears to have done, in backlogs from time to time?
I think if you go back to the auditor's report, you will see there was a human resource deficiency in the department. The unit, I think, was only 1 person for many years and 2 persons most times. So I do believe it's simply a human resource deficiency within the department.
And from whatever inquiries you have been able to make, does that lead you to the conclusion that that has been an issue that has persisted over a significant period of time?
I would say yes. The issue of a backlog is a very old issue. As a matter of fact, the first time I recall the issue being addressed was in 2004. There was a committee set up to look at the backlog. I was on that committee, so I'm very familiar with this issue from 17 years ago. And that's why when we got into office, we worked right away to address this. There's money for consultation. It was due to happen before, because of COVID. It's due to happen second quarter of this year, which is now. Money for a consultant to come in to address and to modernize our immigration laws. One of the things that the new board is charged with is not only to remove the backlog, which we've spent our first couple of months addressing, but to ensure it doesn't happen again, to come up with new policies and new everything to make sure the backlog is addressed as something that shouldn't happen. That's going forward.
If you have a human resources issue, how would a new policy improve things unless you address the human resources issue?
That will be part of the recommendations hopefully in the new policy, that to adequately address this problem, you must first get to the public service, human resource part of it. 2 persons probably can't do this. It may require at least the short term 5 persons. During the fast track, we brought in extra persons, maybe 14 or 15 persons to assist the department to get this thing under control.
How many do you have now?
I think it's back to probably 1 or 2.
But isn't that going to create the very problem that you're trying to avoid,
exactly.
in that you're going to now accumulate another backlog?
And now is the time where the consultant comes on board now. We got a backlog is pretty much almost gone. I can't verify if it's totally gone or not, but if it's not gone, it's not too far from being resolved. We now go to that process to avoid a backlog ever happening again.
Just to go back one step, Minister. There's a backlog of applications, and we can
there were,
and we can look at why that occurred. I mean, one reason why it occurred from 2004 was there was a maximum quota of 25 imposed in 2004, following the report that I understand you were involved in. So there are a number of reasons for that. But isn't there which puts immigration, the number of people who should be allowed into the territory, either as residents or as belongers or whatever, in the context of a long-term plan, a long-term sustainable plan for the territory. Now, Mr. Smith-Abbott's response, I think, was this. Mr. Abbott will correct me if I'm wrong, and you as to what he said, and you can correct me if we've got the wrong end of the stick, that there is no policy. The only policy is the 2004 policy document, and of that, the only policy remaining is the 20 years. Everything else has fallen away, either because of time or because in terms of the quotas, they've simply fallen away. Mr. Penn said at least before 2014, when he became involved. So that's the only policy document. But there's no policy document establishing the appropriate number of people who should be granted belongership status, because that is sustainable over a period of time. That's not a question that's addressed by process and by letting in X number of people a year, purely on the basis of the number of applications and the number of applications that you can process. But is there such a policy?
No, what we're on our way towards that. We've had several studies like the Envision 2040 that looks at infrastructure demands as population grows. We are just finishing Dr. Suma's National Development Policy. The report should be ready, I would guess, in a month's time, that projects what the population is likely to be. The immigration policy, I mean, no country in the world has easy immigration issues, only a few. The immigration issue must feed into, which calls for a very big conversation. What will the BVI population be like, or what we would like it to be at particular times going forward? It has huge implications for several sectors. We know from studying various population models that certain businesses cannot thrive under certain populations. We are around 30,000 now. It limits our economic activity, that we know. But that bigger conversation of what are we willing to do? What population can we sustain? Because if, for example, we can decide tomorrow we want to increase our population by 10,000, one policy statement. The question is, if you're going to grow your population to consider things like economic activity, you must also consider schooling, you must consider sewage, you must consider water production, you must consider power. So this is not a simple little 2-day conversation. This is a big conversation that we're going to embark on very soon, because we have to make those kind of decisions now. Then we walk backwards to see what immigration policies we need to put in place to facilitate that. We can choose a model, let's say like Dubai. In Dubai, their model is we will build our population on immigrants. They are almost 90% immigrant population. The question we have to ask ourselves, is that the way we want to grow our numbers to sustain our economy? Or do we want to grow naturally? Do we encourage our people to get more babies and grow it that way? Or where is that balance in between? We are now starting those very difficult discussions with our people.
Okay.
The outcome of those decisions will then feed back into what kind of immigration policy gives us that particular outcome. The outcome of the study we are doing now would kind of inform what the projections are likely to be for the next 20, 30, or 40 years. Then it feeds back to the immigration policy.
No, I understand that. Thank you.
And is that what the consultant is going to primarily be advising on?
Again, the consultant will do exactly that. What is your ambition as a people? Where you're trying to get to with the country? Your economics, your infrastructure, your environment, what population are you thriving for? And based on what we feed to him or her, then they will say, well, this is the policies you need to achieve that. That's a long-term thing. In the short term, it might be, how do we prevent a backlog? Or what do you want your population to look like?
But don't you already have the answer to how do we prevent a backlog?
No, not yet.
Well, isn't the answer have more people in the unit?
Well, That's too simple an answer because we have to look at what creates a backlog.
Well, as the evidence suggests, and it's the evidence from, it includes your own evidence, is that the backlog was created by a human resources issue.
Well, that's part of it, but
may I finish?
Sorry.
So the backlog was created by a human resources issue because you explain in your response, you point to, as you have done, to the internal auditor's report of 2012. So that creates it. Your answer is that when your administration came in, you introduced the fast track process and you got rid of the backlog.
Reduced
the backlog.
Significantly.
Yes. You didn't reconstitute, you reduced the backlog. But you did that because you put 14 people to work on the job. But now you've gone back down to 1. It might be a bit simplistic as an analysis, but do you not then have the risk that the backlog will start building up again?
Again, it goes back to what creates a backlog. Apart from the human resource dealing with it, it has to do with the number of persons allowed to come into the country and how long they're allowed to stay before they can qualify to even be considered. So it must be a holistic approach to this whole. So again, it goes back to what I said earlier. We have to, as a people, decide what we want the population to look like going in the future. Are we going to build our population on immigrants, imported labor? Are we going to build our population organically from inside? If we are getting enough locals for the workforce, then you have less persons to import. There'll never be a backlog if you're importing few people and they're staying here long enough to get on the ladder to belongership. So we have to look at this very holistically because one thing affects the other. And immigration is not a very simple thing. You know, and you have to tread it very, very carefully.
The proposition you put isn't literally true, Minister. But even if the territory is small, and it's smaller in inverted commas because a high proportion of it is on quite a gradient. So it's the number of people who can live here is a relatively small finite number. For many people, for all sorts of reasons, it is a potentially attractive place to live. And therefore you are going to get people who want to come here. And they will come here and they will apply to come in, they will apply to work, they'll apply for residency, and they'll apply for belongership, probably in that order. There is an issue about the efficiency with which applications can be dealt with. A higher proportion may be negatively dealt with in the future, depending on the policy. But they do need to be dealt with efficiently, else there will be a backlog.
I agree. I fully agree with that. Dealt with efficiently. I think persons waiting 15, 20 years after applying is ridiculous. I think process should be dealt with in a much shorter time, even if it means a denial. Maybe we have a challenge with denying persons for citizenship, for belonger or residence. But to keep somebody waiting, I think is a disservice to them. So I agree on that. I would like to see things happen, responses in the service in general happen more efficiently across the board. Not just in this particular instance, but services in general.
If I can move on, I mean, would you agree with this proposition, Honourable Wheatley, and that is that a grant of belongership is a significant step?
Absolutely, it should be treated sacredly.
And because it provides or conveys a number of important privileges, and notably, yes, firstly, the right to vote, and that you are then free from immigration control.
The right to own property without the license. And
so it requires, I mean, that grant justifies any administration taking care over how belongership is granted.
And furthermore, Minister, all of those rights and privileges are more or less on a permanent basis.
Yes.
I mean, not quite on a permanent
I know
basis.
feel have been retracted, but pretty much a permanent basis.
But
You'll have to.
it's effectively on a permanent basis.
And we will look at the detail of the section 16 criteria, but to pick up a theme that emerged from the evidence of Mr. Penn and Mr. Smith-Abbott, some of the factors that can legitimately be considered when looking at whether an applicant should have belongership status, and that's ultimately the decision of cabinet. But it is, for example, and it's reflected through the process that the immigration board goes through, looking at the extent to which someone has assimilated in the BVI community. So it's not just enough to have lived here the right number of years. It is an important feature of the consideration is the question, to what extent have you assimilated?
And integrated,
Yes.
how much have you participated? Because there are persons who, like the commissioner said, it's a very attractive place to live and work. Some persons come here just for that. They have no interest in our culture. They have no interest in our people. They're interested in just being here. We take a strong view at persons like that. We prefer persons who are more integrated, who assimilate into the culture, into our way of life, and into our values, more importantly.
That reflects the use of a cultural test, which, as understood from Mr. Penn and from the affidavit, is part of the process, because it's a way of asking people to demonstrate their knowledge of the history of the islands, their knowledge of BVI culture, and that's an important part of it, isn't it?
Very much so.
And there again, I don't think it's not something that I'm saying critically, but a legitimate question to ask is, what advantage do you bring to these islands if you get belongership status?
That is an important aspect also, because you want to enhance your community. So you want persons who bring something, expertise or community service or some skill that we don't have. Yes, those are considerations also.
And you don't want anyone, for want of a better word, who devalues belonger status, because again, something that emerged from the evidence this morning is that it's the question that is asked of applicants is, and what they have to show is, do you intend to make BVI your permanent home? And would it be right to say that you would not welcome a situation where belongership status was acquired relatively easily to the point where, but you know, by people who in reality were not making the BVI their permanent home?
It shouldn't be treated trivially. It should be cautiously handled, because even persons who belong us, when you travel, we all judge by this one person, this one BVI lander you may meet. So you want to make sure that the persons who are given this privilege represent pretty much who we are as a people.
And you sound, I mean, you've described it as sacred.
Yes,
And that
it should not be treated trivially at all.
And that is that something that you feel strongly about?
In my opinion, yes.
Thank you. If I just again returning to your written response, please, Honourable Wheatley. But I think hopefully again these are propositions I hope you accept. So, as we understand it, the policy that emerged in 2004, in essence, really has one aspect of it still left, and that is this benchmark of 20 years.
Yes.
That is what it has become. And you accept that that has been applied when considering?
Pretty much, I would say that pretty much. They have been pretty consistent.
Just I think to correct one point in your response, because I'm not sure that this is what you mean. In paragraph A on page 2, the first paragraph of your response, you say that the application of the policy by way of benchmark was an administrative practice deployed by the Immigration Department. You say as a method for establishing an order of priority for consideration of applications. My understanding of the evidence we've heard so far from Mr. Penn and Mr. Smith-Abbott, but also from you, Minister, is that's not really right, because the 20 years doesn't help with prioritisation. It's a it's a bar. Until you get to 20 years, your application is not going to be considered.
Commissioner, if I can go back to that 2004 situation, when that committee was put together, we were given a list of persons. I don't recall what the number is. I think I saw the number somewhere, about 300 or 400.
365.
Right. Those persons, the years range from about 50 years all the way down to a few years, 20 years. 20 was like, because of so many at that time we were trying to do, I think 20 became like the lowest number out of the bunch to consider. Or the most number of persons were 20 or above in that particular set of persons. I think that's where that 20 came from as a way to, let's start here.
But as a policy guideline, it had nothing to do with the backlog. The backlog was going to be determined in a different way. Sets of 50 applications that were, as you say, long outstanding, were going to be considered by the then Chief Minister and dealt with until the backlog went. And
yes,
the 20 years came in once the backlog had gone. The 20 years was a benchmark.
I'm not sure that was the intention of the 20 years, but I'll be corrected.
It's at 1577 if we want to look at it.
Thank you. 1577.
I cannot really give the full history of the 20 years, why it's 20 years, so I'm not going to attempt that.
Well, if you just take up bundle 2 of those 2 bundles, please, Honourable Wheatley. And if you turn just to page 1576 in the first instance.
Mm-hmm.
1576 is a document dated the 24th of August 2005, but it's headed Policy on the Grant of Residence for the Longer Status Memo number 367 of 2004. So it's I think the earliest example that was found by Mr. Smith-Abbott to show the policy as it was. And if you turn to 1577, you'll see there listed the actual administrative guidelines. And I think the point the Commissioner was drawing your attention to is really C, because C is, on the evidence that the Commission has received today, is essentially the last standing part of the administrative guidelines today, as of 2021. And so the idea was that once a backlog to be addressed if B had been cleared, the board would make recommendations as applicants reach the 20th anniversary of their arrival in the territory after the normal screening process. And what we understand from the affidavit and from the evidence today is that sort of statement has crystallized into a benchmark. Yeah,
but I think this should have gone along with a policy change from the same period. I don't think the policy ever happened. It was probably passed in cabinet, but I'm not sure it's enacted.
Well, you're right, because if you turn over to the next page, and I mean, this is obviously promulgated by the Executive Council. Mm-hmm. And so the Executive Council then makes or invites the Attorney General to draft amendments to the Immigration and Passport Act, and also invites the Chief Minister's Office to take certain steps. Mm-hmm. And again, I think work that has gone into the affidavit of Mr. Smith-Abbott, and he acknowledges that it's the work of a number of officers, but nobody has, I mean, factually none of these steps were ever taken. There were amendments to
be made, right?
Well, there were amendments made to the Act, for example, in 2006, but nothing was taken forward here, because one of the recommendations, if you look at it at 1348D, was to increase the qualifying period for belonger status from 7 and 10 to 25 years.
I don't think it ever happened.
It didn't. So what you have is an act that says that belongership by tenure, in the standard way, would be not less than 10 years. An exceptional grant of belongership by tenure would require not less than 7 years. And that was the Act, that was the the public framework. And then we have this as I've said, what crystallized into the policy, which is I'm using the word from your written response and from the affidavit, it's 20 years. And in effect, if you put in an application at 10, 11, 15, it would not be considered until you had reached 20 years.
So it took 17 years to figure this out. Okay.
Well, I think to be fair, it was something that the internal auditor figured out in 2012.
Oh, and still nothing happened.
And she also drew attention to it in her 2014 follow-up review report. But that takes us neatly, Honourable Wheatley, back to your written response, because that is the tension that you are asked to address in the potential criticism. Because on one side, you have a policy that says 20 years, and it is a policy that has not been published. So it's just an internal policy to the department. And on the other side, you have an act that says not less than 10 years. I think your nodding signals that you get the point.
Yes, I get the point.
And it's what I'd like to give you is just an opportunity to perhaps, if you wish, elaborate on your written response to the Commissioner and answer the direct potential criticism, but that by adopting that policy, Cabinet has acted unlawfully or contrary to the purpose of the Act.
Well, when we came in, we started a fast track to address this very issue. So we have moved to address it. We've gotten the backlog down. We're not bringing a consultant in that will examine these things to make sure we're compliant. You know, if you do this audit to any country, you'll find the same kind of problems. We are going to address it. It will be addressed. We came in.
But I'm sorry to interrupt, because what is going to happen is or may be important. But on the face of it, the Act and the policy are inconsistent, because not less than 10 does not equal not less than 20. And secondly, the not less than 20 was unpublished. The evidence we heard from Mr. Smith-Abbott, in fact from his affidavit, says that if somebody made an application in between years 10 and 20, they would be sent a letter saying, we're not going to consider this until year 20. But the policy has not been published. And that seems to me to be unlawful.
I can't verify if it was published or not, but I can tell you everybody knows the policy.
Which was also what Mr. Smith-Abbott said. Yeah,
and I'm not sure a person has sent a letter saying they wouldn't be considered. I think in some cases, they might refuse the application, or they might take the application and put it aside. I'm not sure they actually sent a physical letter saying you won't be considered. I had never seen one.
Oh, right, okay. But
I think the evidence from the affidavit is that it is just put on hold.
Quite possibly.
Okay. But I mean, that's worse, isn't it? Because an applicant who sees the Act thinks that they have a right at least to have the application considered after 10 years, because that's the condition in the Act. Their application gets put on the shelf for 10 years.
And I do believe if it was challenged in court, and maybe it has been challenged, I don't really know, I think they have a very good case.
I mean, and to be fair to you, the Attorney General's put written submissions in, and I think this is fair, Mr. Rowett, isn't it? She says that she doesn't accept unequivocally that it's unlawful, but I think she says it may be.
Yep, I read her submission and I fully agree with her. I wouldn't go beyond what she has said.
No,
well, I think you've made that point at page 5 of your written response, Honourable Wheatley, because you say there that the Attorney General has pointed out the potential for significant questions to arise as to its lawfulness.
This is why we've taken the steps we have taken. Remember, we're in the middle of a pandemic. Things don't happen as quickly as we would like. I think had it not been for the pandemic, we would have been further along with what we're trying to do.
But I mean, I appreciate what you've said about the use of the fast track and the consultant that will be brought in due course. But it's right, isn't it, that this policy still applies today?
Like today, I'm not sure. I'm sure if anyone listening to the COI took an application today, pretty much sure they might accept it today. So I can't say. But I get your point. I get your point.
You haven't, as a result of either the preparation of this affidavit or receipt of the warning letter or preparation of your written response, said we have to stop applying this policy?
I'll have to refer to the Chief Immigration Officer if he has done that or not.
Well, I think as I understand from the evidence of some ministers and also some former ministers, Section 56 makes you in charge of policy. This is
Yes.
a policy. Have you issued a policy?
No, I haven't.
decision?
No,
You
I
haven't.
haven't.
So
I'm sorry to
A written policy, no.
nor publish the policy.
No, not as yet.
But other than that, is there any other matter that you wish to draw the Commissioner's attention to in your written response, Honourable Wheatley?
I've obviously read the response and we'll take it all into account.
No, I think it's quite straightforward.
Thank you. Could I ask you now for your assistance on other matters?
Sure.
Can I explain how I've been approaching things? So we've been speaking about the fast track program or the fast track process, which was time limited, and I'd like to ask you some questions about that.
Certainly, I'll do my best to
Not
answer them.
immediately, not immediately, because prior to the implementation of the fast track process, there was what I'm calling the standard process, and that has, with some changes, resumed as from the 1st of February 2020, because the changes that were brought in under the fast track expired after a period of time. If you keep with the second bundle, please, and you just turn up page, first of all, page 1328, please. This is the it's the 7th affidavit that Mr. Smith-Abbott has provided to the Commission. The second one, in which he provided some information on belonger status. If you work through to page 1331, please, Honourable Wheatley. If you see at paragraph 9.2, what the affidavit does is to set out Section 16 of the Immigration and Passport Act, which is, I think, the key provision that we're concerned with, as in force as of the time of drafting of the affidavit, which is the 10th of September 2021. And so we have there a number of different ways in which individuals can be granted belongership. I mean, in particular, I think I'd focus our attention on is Section 16.3, which says that a person may be granted a certificate of belongership, and it would be granted by Cabinet after consultation with the board, where they are of good character, not less than 18 years of age, have been ordinarily resident in the territory for a period of not less than 10 years immediately prior to the application, have had a certificate of residence for a period of not less than 12 months, and has stated in the application that the intent to make the territory his or her permanent home. There are provisions, if I ask you just to turn up 1334. You'll see at paragraph 10.7, the affidavit sets out the law in relation to what it means to be ordinarily resident. And that means that the applicant can only be absent from the territory for a specified period of time. And if they exceed that time, that will affect the application. And if you look at 10.8, it refers to subsection 16.10, where it says that there can be grounds where absence can stop time running against you. So, for example, if you are on government service and you have been posted, let's say, to London, it would be wrong to not to allow you to continue to accumulate the appropriate time for ordinary residence. That page also allows me to draw your attention, Honourable Wheatley, to subsection 16.8, which gives the factors that Cabinet has to consider when dealing with an application. And that is, I'm going to summarize, but I'm sure you'll be familiar with them, but the economic situation in the territory.
Mhm.
And that means it's a specific one, because what you are asked to consider is whether if you grant belongership status to an individual, would that affect the ability of another to work? You then have to look at whether the person has established a close personal connection with the territory, and you then have to consider whether the person's character and previous conduct are unexceptional, and whether their continued residence in an association with the territory may afford some advantage to the territory. Now, some of this we've canvassed, because when I was asking you questions about your own perception of the importance of belongership status, but they're reflected in these provisions, are they not, Honourable Wheatley?
Can I ask a question?
Of course.
In A, I think it's a kind of a bit of a narrow interpretation of A. The economic situation. I think it means just that what the overall situation is in the territory, not so much to the individual. For example, if you're going through a period of devastation like we are now, not simply how the person's affected, but also the country. That's how I kind of see that also.
Well, yes, these are factors which Cabinet have to take into account. It's mandatory. Right. The Cabinet aren't prevented from taking other things into account. So the fact that this may be quite narrow, that is, that Cabinet have to consider whether somebody's coming in to a trade which is, in inverted commas, fault. That's something they consider. That's quite narrow. They've got to consider that, but there's nothing to stop Cabinet considering, as you say, other economic factors.
Okay, thank you.
And that is a point that Mr. Smith-Abbott makes in his affidavit. If you go to page 1344, please, Honourable Wheatley. At paragraph 25.3, when discussing the process, and the point that is made in the affidavit is, up until it gets to Cabinet, everything is a recommendation.
That's correct.
It could be a recommendation to say no, it could be a recommendation to say yes, but it's Cabinet that must make the decision. And at 25.3, the point is made that Cabinet can receive further advice, and the example is given. And the example, actually, we looked at it with Mr. Smith-Abbott. It's actually the Attorney General, as it says there, referring Cabinet to the criteria that they have to apply. But if you look at 25.4, what the affidavit then continues is that Cabinet will balance any loss of revenue in approving applications with the potential economic benefits of more closely integrating the applicants in the community. So the point that Mr. Smith-Abbott made was that if you approve an applicant, you lose a certain amount of revenue because they don't have to pay for work permit, they don't have to pay for everything else. But you have to balance that against the potential economic benefits of having someone who's integrated in the community, wants to live here, maybe someone who creates jobs, etc. So that may go to your point about that there may be wider economic considerations that the Cabinet wants to take.
That person who's now a belonger, before becoming a belonger, might have been sending money because they're not sure if they're going to be here as a belonger or move to someplace else, might be sending funding someplace else or investing in someplace else. Now, when a person becomes a belonger and they have that sense of attachment to this country, all of a sudden, they may buy property, they may build a house, they may open a business because there's more certainty about their future. And that's what this is referring to. So yes, you may lose the $700 on the work permit, but that same person has now spent $500,000 in your economy. That's what we're looking at here, the opportunity cost of giving that person belonger status.
Now, against that background, and I can take you to more parts of the Act if you need it. But when, as we understand it, the standard process was application is made, Mr. Penn's team collate the material,
That's correct.
It then goes to there is then an interview process, which involves a member of the Board of Immigration.
That's correct.
A cultural test is taken. There is a point system. And all that information goes to the board, which makes a recommendation.
To cabinet.
To cabinet. A profile is prepared.
Mhm.
And all of that material underpins a cabinet paper, which you as minister will take to cabinet.
That is
And
correct.
so what cabinet will have is the profile as well as all of the other documents. And so then cabinet can make its decision. But in terms of how cabinet makes its decision, and the act is clear, it's may. So, you know, it's not automatic that if you have scored 150 points on the point system, the board is unanimous in its recommendation, that cabinet says this is a credible application. You still don't have to say yes. But and this is obviously speaking of your time in ministerial office and as a member of the cabinet, would a fair assessment be that the approach of cabinet is to look at the application in the context of the act?
Technically, yes. We do expect our technical persons to be compliant with the act. To say we look at every single applicant like that would be impractical to do, because sometimes we may have 200 applicants. We have a finite time to meet at cabinet. So if you don't get the paper in time to go through every single one, we go through, but someone might go through every single one, but I can't say we go through every single one. It may take a lot of time sometimes, depending on how much time we have to consider these things. But we do depend heavily that all the proper vetting was done before it got to cabinet.
But the factors that you will have in mind, though, must be,
Yes.
Is someone of good character?
Yes, the paper will say under what section this person is granted this, and any concerns they may have would be in the paper.
But you have to exercise a degree of independence as the minister, as the
Yes.
cabinet member making the decision. So will you be asking yourself the questions of, you know, am I satisfied this person's of good character?
So it's one of the persons I wouldn't even know. So I have to depend on the others, immigration, that they have done that vetting for me.
But my understanding of Mr. Penn's evidence was that he provides all of the information,
Right.
to
We go through and
to the board, and they then make a recommendation
the cabinet.
to cabinet. But who considers, because this is a precondition under the Act, who considers whether somebody is of good character?
I think everyone who comes in contact with that application will be.
So cabinet would consider, is this man of good
Oh yeah,
character?
we'll go through the list of names. Anybody jumps out of us, we go through the various attachments that they have there. Because there are instances where you may have a question about, well, I heard this thing about this person, can we go and verify? Is this the same person I heard about, or something like that?
But also you get details attached to the application.
Yeah, I'm saying the profiles are there.
Previous convictions and all of that.
The profiles are there, but they shouldn't really come to us with previous convictions. I don't think they would pass the board with certain things. I don't know how many applications are denied, but I think the ones that come to cabinet have pretty much been vetted and are in good standing, so to speak, with all these things.
As we understand the process on the evidence is that all of the applications come to cabinet. So cabinet.
I wouldn't know that.
Well, because the board cannot make a decision, it can only make a recommendation. The practice seems to be that, let's say there are 5 applications that the board's recommendation is that they should be refused. That recommendation is still put to cabinet to make the decision.
Okay, let me clarify. When persons submit the application to immigration department, I'm not sure where they go. I don't think they all go anywhere. They may be missing documents. They probably are sent back or rejected there. So I'm saying, I wouldn't know how many persons have applied and how many were rejected. I would only know the ones that the board has considered and sent to cabinet.
Yes.
There are others besides those, I'm sure, that I would never know about.
Well, I think what the affidavit explains is that when Mr. Penn's team does the review, and I'm saying as Mr. Penn's team, it may be just that he has an under-resourced team of one, but when that review is done, if there are missing documents,
Right.
the applicant will be told about that. But you're quite right that you get everything, you will see everything that the board sees as a cabinet member.
That is correct.
But the point I was making, Honourable Wheatley, is that you get all of the applicants. So what the board doesn't do is act as a filter. It doesn't separate the applications into a pile of refuse and accept. It will make recommendations in that way, but it will then put everything to the cabinet for a decision. Because there is on the papers, there are instances when cabinet has said, we don't accept the board's recommendation to refuse, we will approve the grant of belongership.
That is correct.
So it takes us back to the point that obviously cabinet has an important role in this. It's only cabinet that can make the decision.
Final decisions, cabinets.
And those factors that you have to consider must be the ones that you have in mind. You must ask yourself, is the person's character and previous conduct unexceptional?
Mm-hmm.
That's right, isn't it?
Yes.
And you will ask yourself about whether continued residence and association with the territory affords some advantage to the territory. Because these all feed back to that, the key points you yourself were making. It's really about your point that it's sacred. It all comes back to that, doesn't it?
Very much so. But we do, depending on the number, we do go through meticulously all the paperwork involved.
Can I, that's the standard process. Can I look with you just in relation to the fast track process? If you turn in the same bundle, please, Honourable Wheatley, to 1663, please. Cabinet memorandum from your ministry, memorandum 289 of 2019, I think 20th of August 2019, and it is useful as a starting point because it sets out what I'm going to suggest, Honourable Wheatley, was the sort of policy behind the decision to have the Act amended in 2019. And we see that, and this is, we know that there were two acts in 2019. This is in relation to the first, which was assented to by the governor on the 12th of June 2019. And it explains in the paper, this amendment allowed for a special fast track process to be developed for expatriate workers and those residing in the territory for a period of 20 years or more, without gaining status to be able to do so. These persons had the opportunity to apply for residence and belonger status or belonger status only, depending on their pre-existing qualifiers. The Clear Path to Regularisation, Residency and Belonger Status Programme is a special project initiated and driven by the Premier, does not require a deliberation of the Board of Immigration for applications received, but is approved by Cabinet's discretion as stated within the Act. The process specifically requires applicants to submit their application and make payment up front, complete a written exam, and submit all of the same documentation that persons would have originally submitted through the normal process at the Immigration Department. It then lists a number of documents and refers to, as you've mentioned, the profile of an applicant that comes to Cabinet. And on the third paragraph, under this expedited process, a timeline of 3 weeks was allotted to allow persons to submit the required forms and documents. Applicants were required to pay upon submission of all applications a fee of $810. Now, I think this came in on the 3rd of June 2016. The second act, and I can take you to it if you need to see it, but the second act expanded the time period. So in fact, the period was 3rd of June 2019 to 1st of February 2020. And you then dealt with it in that process. And when we talk about the fast track, I think we need to separate the legislative change from the procedural change, because the effect of in terms of procedure was firstly that the immigration board was not involved. That's right.
That is correct.
And so it was the job of the immigration department to collect the material and submit it to the cabinet. That's Mr. Penn's evidence.
We had brought in extra workers. It was more than the immigration department. We had brought in some retired immigration officers and persons we trained to work along with the immigration officers to replace the work of the board, so to speak.
Yes, but
I'm sorry to interrupt. That's not quite the evidence we've heard, Minister. More people were brought in,
yes,
to do the job of the immigration department, that is, collect the information. That didn't replace the job of the board. The board had
legislation. No,
the board had a job to look at these, analyse, and make recommendations. That's not the evidence is that that's not what the
the board didn't participate in this one. Principal Axel applied in this case because we didn't amend that part.
No, so the immigration department did somewhat quicker because they had more people.
Yes,
but they did their usual job, as it were, but then sent everything to the cabinet rather than the board.
That is correct.
Thank you very much.
So it was down to cabinet to do the business, so to speak. And on the procedural side, and this was from Mr. Smith-Abbott, what the process created was that if you already had belongership status, if you had resident status, you could apply for belongership.
That's correct.
Pay your money up front and go through the fast track process. But if you had not yet achieved resident status, you could do a combined application.
Because the normal process is to first get residency and 12 months after.
And what was removed was the 12-month requirement.
That is
between
correct.
Residence and belongership.
That is correct.
Now, we've seen the figures. There was obviously an increase in applications that were considered and grants of belongership. But can you deal with this, please? You've spoken, the effect of the fast track was that if you had someone who was sitting at home and they were a resident, they could make an application for belongership. If you had someone who was sitting at home and they were neither resident nor belonger, they could make a combined application. That's right.
That is correct.
All they needed was $810.
That is correct.
Provided they fulfilled all the other requirements. But how did that clear the backlog? Because the backlog was already there. So the applicants were already there. How did creating a new basis for people to come and make applications, fresh applications, help with the backlog?
Some of the persons who got belonger were already in the system. The extra help. Some were new applicants, but some are already there in the system. We simply speed it up.
So is this true that most of the people who were in the backlog made an application under the fast track system?
I can't verify that.
No, okay.
I can't verify that.
But at least anyway,
it may seem
some
so.
of them.
Yes.
Some of the backlog made an application under the fast track.
Yes.
And that sort of got rid of
significant portions.
Significant numbers. Thank you.
If you turn, please, Honourable Wheatley, to page 1.
What's, if I may?
Of course.
Because I know there's a concern here about who these persons were, that the board wasn't involved. These persons who would enter the fast track were persons who may have been married to persons already and had significant presence in the territory. They were not strangers.
I think the evidence is that those who applied under marriage were suspended for the period of the fast track. I think.
I can't be sure. There's only one system at a time.
Well, I think marriage remained unchanged.
I think marriage remained unchanged. Yeah, I don't think it was changed.
I'll take you to the Act in a moment, but I mean, your point perhaps illustrates that the purpose of the regularization, the clear path to regularization. It wasn't called the fast track, but what you were intending to do was to facilitate belongership applications as that policy paper that we looked at, for expatriate workers and those who were residing for a period of 20 years or more. I mean, would it be fair to say that the purpose of the policy wasn't to allow someone who arrived 3 years ago to make an application? It was really intended to try and facilitate
someone here
those.
for significant time, yeah.
And this takes us back, I think, to a point that I've canvassed with you before, that 20 years points to a period during which you might have expected someone to have assimilated.
That is correct.
And so again, that's a safeguard, isn't it? It's not about a rush to granting belongership. It's actually about safeguarding belongership whilst facilitating the process. Would that be a fair way of putting it?
I think so.
I mean, just to close this point off, because I don't think this matters in the context of what we're talking about, but 1575, which is a table of the numbers of persons granted belonger status. And that says at the bottom, no applications by marriage were processed during the fast track initiative. That was the only point I was making, Minister.
Okay.
So I think, and as you'll see from the numbers, all of these people who were granted belonger status during the fast track period, there were about 1,200, not due to marriage.
Okay, we'll come to the table.
Yeah.
Could I ask you to go back to 1348, please, Honourable Wheatley?
1, 3, 4.
If I take you to paragraph 33.4, do you have that?
Okay, I do.
Thank you. Now that is a helpful part of the affidavit because it sets out the changes that were brought in by the 2019 amendments. And so the two parts of the Act that were changed was 16.4 and 16.5. Now 16.4 provided that where in the exceptional circumstances of any case or for any other reason, the Cabinet considers it fit to do so, it may in its own discretion grant a certificate referred to in subsection 1 to any person who applies for the same in the prescribed manner and who A, is of good character, B, at the date of making the application for such a certificate, ordinarily resident in the territory, and C, has been so ordinarily resident for the period of not less than 7 years immediately prior to his or her application. And then at 5 is where in the exceptional circumstances in a case the Cabinet considers it fit to do so, it may in its own discretion grant a certificate referred to in subsection 1 to any person who applies for same in the prescribed manner and who in its opinion has made significant and consistent contributions to the economic and social development of the territory, or has been ordinarily resident in the territory for a period of at least 20 years. So I think section 16.5 in its original incarnation was what I've called the Rockefeller provision.
Absolutely.
Because I think it seems to be only Mr. Rockefeller that ever benefited from it.
I think
and
so.
It's gone back to it needing to be 50 years anyway, after February 2020. But that's the two changes. So what your amendments kept was ordinary residence is still the same. You still have to, there are only still limited grounds on which you can be absent from the BVI. Good character was still an important characteristic. A need for a time period with, of not less than 7 years in this case. Now, again, my questions now are against that background. Firstly, what did you understand? We've looked at the policy, but what did you yourself as a Cabinet member and as Minister for Immigration understand was the purpose of these two changes, these 16.4 and 16.5?
Well, to allow for persons who are here over 7 or 10 years to get regularized. Using 20 as was the practice benchmark.
So the 20 years benchmark was still an important part of that.
It was. We promoted it. We had several town meetings about it. Several numbers are thrown around as well as the best number to use. Some said 15, some said 19, some said 25. We settled on 20 after public consultation.
You see, can
It,
you
it
help
caused,
a
caused a
little?
lot of heated debates.
Can you help a little further though with that? So before promulgating the changes in the law, you had a number of public meetings.
Oh yes, all of
And
them.
what you were asking the public, what should be the benchmark? So it was clearly known to anyone who applied under the fast track that
Not in the beginning. Our time wasn't set.
no. Well, I mean, your reference to 20 echoes the policy, doesn't it? Because it talks of people who've been resident for 20 years or more. But was it? I mean, when you set out on the fast track, was the benchmark was going to be 20 years?
No. When we set out with this fast track, we had public consultations. The first meeting was at the college, and we went to, I think, to every village in the BVI, discussing this very issue of what should the time be. The time ranged from 15 years up to 25. After much consultation, we settled on 20. After heated debates, we settled on 20. That came after the public consultation. 20 were settled. It wasn't like we started out at 20.
That point, you ended at 20.
We ended at 20
But
for the sake of the fast track.
All right, but what does the 20 signify? How did the 20 operate in relation to these provisions?
I think it's what I said earlier. I think in the person's mind, notwithstanding what the law says, they figure that by this time you would have assimilated well into BVI culture and to BVI life. In person's mind, I think they figure, because it was proposed one time, why not make it 10 years or 15 years? And they said, oh, no, we're not sure you've properly assimilated by that time.
Was there any reason why, when you were amending, you did not think of amending the period in 16.4 to not less than 20 years?
I think this came after the consultation. The 20 years came after the consultation, if memory serves me right.
I may have misunderstood you. I mean, what I assumed was that before passing the law, you had consultation.
Yeah.
Right. So you did a period of consultation. From the feedback you had from consultation, you came to the view that actually it's going to be 20 years as the benchmark.
By popular demand.
Popular demand asked for 20 years. And then you've got to take the bill through the House of Assembly. Why not, given the popular demand that had been made of you, why not amend section 16.4 to say not less than 20 years?
Oh, let's see. I really can't say at this point in time why that wasn't changed to 20.
But sort of, if I can try and summarize it, we've seen the changes in the law that went through the House of Assembly and were given a say.
4C.
4C, yes. But what you're saying is, again, going back to popular demand, the point you're making is
For the fast track, yeah.
The benchmark for the fast track was going to be 20 years, and no one could have been in doubt about that.
It ended up at 20. No, when we started out, there was no benchmark.
Yeah, it's my phrasing.
It's the public consultation, we ended up at 20 years. And the minutes of those consultations will show the different numbers that were proposed.
I'm sorry, just to look at the new the change subsection 4, it's actually at page 1348.
That's where we are.
Yes. 4 is where in exceptional circumstances of any case or any other reason, that means whether the circumstances are exceptional or not. So that's OTOs. The Cabinet considers it fit to do so. It may, in its own discretion, grant a certificate referred to in subsection 1 to any person who applies, so they have to make an application, is of good character, is at the date of making the application for such a certificate ordinarily resident in the territory, and has been so ordinarily resident for a period of not less than 7 years, immediately prior to the application.
Yeah, but memory serves me right, 20 is more than 7. They said not less than 7.
No, don't just leave 20 to one side for now.
Oh, sorry.
But so subsection 4 is 7 years. So that
not less than 7 years.
Not less than 7 years. So that, as it were, seems to me to be the main provision that was changed. A change was also made to subsection 5, which had only ever been used once, the Rockefeller provision, and that was where there had to be exceptional circumstances, and the Cabinet again is given it a discretion to grant a certificate on the basis of an application where an individual has made significant and consistent contributions to the territory, or has been ordinarily resident in the territory for a period of not at least 20 years. But I assume that most applications would have been dealt with under the new subsection 4.
But there are two separate categories of persons. One is economic and one is tenure. So one is tenure only, one is economics and tenure.
No,
in 5.
4 is tenure.
4 is clearly tenure, yeah.
Clearly tenure.
Yeah.
5 used to be
50,
and now is again significant consistent contributions to the economic and social development of the territory. But it then says, or has ordinarily been resident in the territory for at least 20 years. So that's both.
Yeah. Also,
sorry, either or.
Either or.
Sorry, so it's economic or 20 years residence.
In 5.
Yes.
4 is strictly tenure.
But strictly tenure, but it has good character, and you have to be ordinarily resident at the time of the application as well. But most applications would have been dealt with under 4 because 7 is less than 20.
Yeah.
Most of the applications based on tenure would have been dealt with under 4.
That's correct.
Yes. It's me being slow, I'm sure, Minister. I just wanted to make sure that I'd understood that correctly. Yes.
Could I ask you, Honourable Wheatley, just to look up the first bundle? I'm just going to take you to some Cabinet memos that as we understand the process, Cabinet was sort of served with batches of applications, obviously under cover of a Cabinet paper.
Yeah, as they're processed, they're batched and sent to Cabinet.
Can I ask you that as we look at these, please just don't mention anybody's name.
Okay.
And I will try to remember to do the same, but it's a relatively small point. But if I take you to 724 in the bundle, please. It's 5th of December 2019 memorandum from your ministry dealing with batch number 6, and it's memorandum 443 of 2019, and it sets out and we see it, the purpose at 5 is to allow for persons who've resided within the territory for a period exceeding 20 years to be granted residence and belonger status. And then if you look under legal implications, this is the point I want to take you to. What the Attorney General's Chamber's input into the paper is that the size of the number of applicants, and it said in this case it's 67, and the short notice for comments on the Cabinet paper does not provide me with the requisite opportunity to determine whether or not the applicants have qualified for the grant of resident or belonger status, and that there are no disqualifying factors such as criminal convictions, frauds, etc., whether in or outside the Virgin Islands, which is a relevant consideration in these matters. I proceed on the assumption that the Ministry has conducted the application and that they do in fact qualify under the Immigration and Passport Act for the status that they have applied for. In any event, a certificate granted is subject to revocation for fraud, false representation, or concealment of material fact and imprisonment, amongst other considerations. If you then turn to 735, we see a different paper, but it's batch number 7. It's on the same day, but it's memo 444 of 2019. And again, if you turn through to 737, please, Honourable Wheatley, you'll see that the Attorney General's chambers have made the same comment under legal implications, but this time referring to the size of the applicants as 48. So the two batches going in on the same day, it's over 100 applications. And the Attorney General's raising concerns that there's insufficient time to consider them. Were those concerns of which you were aware?
I'm sure it would have been discussed in cabinet, and if and maybe our concern was answers, maybe all our concerns were answered, whatever the AG was at the time. I don't recall the discussions, but I would imagine that there were discussions, concerns of this magnitude. The paper might have gone forward unless they were resolved. So I'm going to assume that they were resolved. The concerns.
The attorney's concern was that he hadn't had enough time to go through all of the applications to make sure that the preconditions had been satisfied, and that, well, the preconditions had been satisfied. But given that there was no board to look at these and make recommendations, who did that exercise? The attorney didn't, we know, he says he didn't. Who did that exercise?
Would have been on the immigration office of this team. They would have done that at immigration.
Well, no, they gathered together the information. So
Right.
they gathered together whatever convictions somebody
Yeah.
might have had.
Uh-huh.
But who made the decision? Who assessed whether an individual, one of these individuals, was of good character?
Oh, okay, I understand the question.
The information was there.
Yeah, it's clear down to cabinet at that point in time to look at all the names being brought forward.
So, I mean, the board would have looked at it if they'd been in the process. But,
Right, if the board was
but
involved,
the cabinet did that assessment.
we would have had
Yes,
to go through each of the names there.
yes.
So I think this concern must have been addressed. I would assume it was addressed.
Yes, thank you.
Could I just ask you to, they should be on the table in front of you on a cabinet minute, number 32 of 2019. That's a minute from the 22nd of November 2019. Again, please don't mention any names. But if you go through, Honourable Wheatley, to I think it's four pages in, sort of to page 8, if you like. The pages are not numbered, unfortunately, but go to the 4th page and then the back of the 4th page.
The table?
Next page
Okay.
after that.
Deliberations?
So you should go to reach a point where it says decision sought number 20 at the top. Do you have that? And if you're further there, you should get to a point where there is a list beginning number 43 at the top.
Okay, I'm not sure we're on the same page.
If you start from the beginning, if you
This is oh, sorry, I'll say it now, yes.
yeah. Have you got it?
Yes, I do.
So there's a long list of names which starts at number 43 and then end at number 100. Is that right?
No, I'm not seeing that list, 43 to 100. I am not seeing a list.
Shall we start together? I think it's quicker if we just start together with the first page.
This is on sort 20, top of the page. Memo
Right,
4, memo 403.
Underneath, right? If you turn over, and you'll get to memo 404 of 2019.
Okay.
You've got that.
So
Turn over again, and you'll get to the bottom
okay.
memo 405 of 2019. Do you have that?
I have it now.
Right. So this is memo 405 of 2019, which you presented, and it is headed "Applications for Certificates of Residence and Belonger Status, Immigration Regularization, batch number 04." Now, again, I'm not going to mention names, but if I just read out the deliberations. The Minister for Natural Resources, Labour and Immigration presented this paper. The Attorney General raised the issue of the applicant, and then the name of a person is given, who is currently imprisoned in the US and serving a 10-year sentence for rape. The Premier responded that the applicant's parents had made representation and informed him that the US court had indicated that they would allow the applicant to serve out his sentence in the territory. The Premier made it clear that he was not condoning the crime, but that the BVI was the only place that the applicant knew. The Attorney General said that the Cabinet has discretion, but as the Attorney General, he has brought this matter to the Cabinet's attention, that this is the status of the imprisoned applicant. The Premier mentioned there was another case involving, and another name is given, who would be applying for a similar consideration. That person was not born in the territory, but had lived here for over 30 years. The chairman said, while we want to be sympathetic to these persons, what was the plan for further rehabilitation for them? The chairman stated that the BVI should not be a dumping ground for persons who did not behave in a good manner while overseas or considered a place that was a home for non-law abiding citizens. The Premier and his ministers conferred on the matter and agreed that the applicant be deferred. And Cabinet then decided on the 99 other applications, but deferred that one application for 3 weeks. Now, I should make clear that the chairman at that point was the acting governor, Mrs. Rosalie Adams. So going back to 1348, what you have is a convicted rapist serving a sentence in the US, applying for belongership under, it seems, the fast track program. And you then have another person who is also certainly, it appears, we could presume, in prison for a serious offence, applying under the same basis. What was the basis upon which Cabinet was considering giving 2 serious criminals, one we know is a rapist, belonger status?
Everyone who were considered here persons who are either known to us personally or whose families we know personally. In this case, one of these persons that I went to school with, things happen in life. I went to school with him.
Sorry, your voice is dropping a little bit, so just speak up.
I'm saying these are persons, they're not strangers to us. The one person here, this is sympathy. It's somebody I went to school with who I guess was caught up in a situation.
Pause there. There are 2 people mentioned here.
One of them, I'm not going to call him, but one of them I had known all my life. I went to school.
Is that the other person?
Yeah.
Not the person serving the sentence in?
No, the person serving the sentence.
The person serving the sentence?
Sorry, the other one.
The other one. So,
well,
let's call them criminal 1 and criminal 2.
So criminal 2. I'm talking about criminal 2. It's somebody I went to school with, who I know personally. And we just thought it was the humane thing to do in this case. And these are things you do almost against your better judgment, so to speak, but the humanitarian in us says this is probably the right thing to do. Might not be, but this is the right thing to do. The other one, I know his parents very well. These upstanding persons. We just were trying to be sympathetic to their cause, to have their son here with them. So that's what that was.
Did you make an assessment that these 2 individuals were of good character? That's a precondition.
I said these are persons that lived there. They just happened to be abroad at the time.
No.
Yeah, they are good people.
So
who may have been caught up for some reason in a situation.
So you made an assessment that these 2 people were of good character?
Yes, notwithstanding the situation they were in. Things happen to persons. It was a sympathy call more than anything else, just to bring some relief to families.
Did you ultimately, as Cabinet, grant these 2 individuals belonger status?
I really can't recall. I really can't recall. Well, several hundred persons. I don't recall if it was done. It might have been done in the end. I really can't recall.
I appreciate that as part of the fast track that you were dealing with several hundred persons, but not many of them are rapists serving a sentence.
These were anomalies, yes. I remember the cases very well.
Given that you remember the cases, yeah. Honourable Wheatley, did the Cabinet grant belonger status to them?
I have to go back to the record. Because it was before. So we didn't make a decision here. I don't know if it happened subsequently. That I can't recall. It didn't happen here. They were removed, like the paper said.
Well, I think the person serving the 10-year sentence for rape was deferred for 3 weeks. That's the reason I asked the question.
Now the question is, what happened after 3 weeks? I'm saying I don't recall what happened after 3 weeks. So maybe it was brought back after 3 weeks and granted. Maybe when it came back, it was thrown out. I really don't recall. The record would have to show what happened after 3 weeks.
I mean, the questions that arise relate to the process. I'll come back to, and it relates to the process in 2 ways. If you turn up, please, page 1348.
Sorry?
In bundle 2, we're back to bundle 2.
Oh, which number?
1348, please, Honourable Wheatley.
No, I understand the point of the character. It's not lost on me here, but there were more we considered in those particular cases. And the attorney did make views known. 138?
1348. If we take it in stages, please, Honourable Wheatley.
1348, sorry, I'm in the wrong section altogether. So
I think you're in bundle 1. I
so
think originally, so you should be
I'm not seeing a 1348.
Thank you.
And 348.
Now, I'm just so that you have it in front of you, I'm taking you back to the changes in the law that were made. And so those are where you have an application for belongership under the fast track scheme, the regularization scheme. There are 2 ways in which people can get belongership status. And you've spoken about belongership as a sacred thing. Now, what appears from the minute is that Cabinet, and what appears in fact from your very candid evidence today, is that the Attorney General and the Chairman of Cabinet raised concerns, but Cabinet, although they deferred it, considered that these were viable applications. And the question is, I mean, if you just take the example of we have to take that you have a man who is serving a 10-year sentence for offence of violence. Under 16.4 or under 16.5, what is the basis on which Cabinet can reasonably reach a conclusion that a rapist should have the sacred gift of belongership?
His family's here in the BVI. Was a more of a humanitarian gesture in this case. If I'm not mistaken, I think the person was supposed to serve the jail time here. So it's not like we put them out of jail. Either leaving them from jail, they were serving a jail time in the BVI. But
when you say that this was on humanitarian grounds or whatever,
so to speak, yeah.
when the Cabinet, because the board weren't involved in these cases, when the Cabinet came to assess the applications, which, as you said, they had to do because nobody else was going to do it, did they have any guidelines, first of all, written guidelines for considering the applications?
I don't recall written guidelines.
Did they have any?
The process of what you would need to submit to be considered is prescriptive. You need to put this record, you need a birth certificate.
But things like good character require a judgment, because somebody may have a.
No, I understand that.
I mean, somebody might have a parking ticket or have a conviction a long time ago for shoplifting.
Commissioner, I would say this case is an anomaly. It's probably a 1 in a million chance of this happening.
But we'll come back to this case, no doubt. But in terms of the process, which I'm most interested in, there were no written guidance. There's no written guidance as to how you approached, say, good character, which requires an assessment. Nobody else considered it, so Cabinet, as you've accepted, had to consider it. So if there were no guidelines, how did you approach, just generally, forget about these 2 cases?
Again, knowing the persons involved, personal knowledge, or the application, whether it's a record or not.
So
again, I'm saying I don't recall if this person was ever granted belonging status. It was deferred. Now, during a period of deferment, I'm not sure what happened in there. if something was done in there. I am not sure what happened. I really don't recall.
But looking at the process, and as I say, just putting these two individuals aside for a moment, who went through the papers and said, and came to an assessment that this person was of good character?
All of us, and the AG flagged that one. But the circumstances here were more than just character. But the AG flagged, we all go through all of them. All of us go through all of them. And different persons will have different concerns.
But if you look at 16.4, the two things that a person has to show here is firstly, not just good character, Honourable Wheatley, they have to be ordinarily resident. And the Act does not allow time in prison as an excuse for time not running against you. If you're on government service, or if you're serving in the armed forces, it doesn't count against you. If you're in prison, it does. Now, you have two serious criminals serving prison time outside the jurisdiction. And what, again, taking it back to the Commissioner's point about process, how did you assess the notion of ordinarily resident?
I can't say that I know how long they were in prison. Saying they were sentenced to 10 years doesn't say they were in prison for any period of time. That I don't know. Well, they say they were sentenced to 10 years. They didn't say they were in prison already.
Well, did you ask those kind of questions of yourselves?
The paper was deferred for a reason, so investigations could be done to answer those kinds of questions.
Because
but I don't recall. This is a long time ago. But a lot has happened.
But because it's the other thing for us to take into account is 16.5, and 16.5 says that someone has been ordinarily resident in the territory for a period of at least 20 years. Now, the point there is that it brings again that ordinarily, the phrase ordinarily resident is important. And did you not have at the time any guidance or any guidelines that you decided amongst yourselves as a cabinet? You're the decision makers to say this is how we will approach the concept of ordinarily resident.
As a formal, prescriptive, written down thing, the answer is no. I mean, everyone have a general notion of what good character is. You're not involved in nefarious activity. You're not X, Y, Z. Well, these are general guidelines.
I think, with respect, it's very difficult to understand how any rational cabinet could come to a conclusion that someone serving, that is, they have been convicted, serving a 10-year sentence for rape, qualifies as an individual of good character.
Like I said, other considerations were given in this particular case.
Well, that takes me to the next question about process, because you say other considerations were taken into account.
Like family ties and so forth.
Family ties, you personally knew the family. I mean, in different ways you had contact with both criminals.
For one individual, yeah.
Yes. The Premier spoke to the parents directly. Going back to the process that you instituted under the fast track, where in that scheme does it allow for Cabinet to import into the process its subjective assessment?
I think when we envisioned the fast track, I don't think anyone expected something like this to actually show up. It wasn't envisioned that a case like this would honestly show up. I think it surprised all of us that we had this situation here. It's just an anomaly. It was never foreseen, because most of the persons who we envisioned would be in the fast track were persons living here. They will have children here, they have families here, they have strong ties here. This was never envisioned. I could honestly say I never envisioned this. So it sprung upon us and we had to make a decision. But it was not an easy decision to make for the reasons you've clearly pointed out.
But within the program, was there a promulgated policy? Did people know that they could make representations to the Premier?
I don't see why they would do that. They would submit the application to immigration. We're not involved with that.
But if you look at 37,
no, I saw it because clearly the gentleman was not in the BVI at the time. So the parents who were here would have gone to the Premier to make representation on his behalf. The parents who live here would have gone to the premier, but can you consider this from your heart? I think that's what happened. So it's an anomaly. We could look back in hindsight and said, maybe we should have done X, Y, Z. It happened. It's like the one individual, somebody I went to school with, is somebody I grew up with.
But do you not think that that could affect your perspective in the wrong way? If this is someone that you went to school with, how do you balance that against the obligation on you as a member of cabinet to public safety?
Yeah, again, it's an anomaly. No one saw it coming. Going forward, we have to be very mindful of going forward, that these things do exist.
Well,
I'd never seen it before, or even heard of it before, this particular situation.
If you look, and this is more specific, but if you, I mean, at the time, what we have is there's one application in front of cabinet, which is the application from the rapist in the US. You have the other one, which is pending. So it's not something that cabinet has to consider, and you defer the first application. Now, in deferring it, what the chairman raises is it's that the BVI should not be a dumping ground, and the BVI should not be considered a home for non-law-abiding citizens. Did you ask, and you mentioned that the individual may be coming back to serve a sentence in the BVI. Did you ask for a risk assessment?
I personally didn't. I don't recall asking for that.
Or do you know if anybody else did ask
I
for a
don't
risk?
recall.
Do you not think that that would have been a sensible step for cabinet to take?
What I'm saying, maybe it was done. Maybe that's why it was deferred, to get further information about that situation. And I can't say at this point in time, if in the end it was granted, I don't know if it was actually granted in the end. I do not know.
But you've explained that you had hundreds of applications. Yes. You've described it as an anomaly, which leads to the conclusion that there weren't many applications being made by serious criminals. Is that right?
Only two I know of.
So you have
going through the list of the two I know of.
Two you know of. Given that it's only two, how is it that you cannot remember
if it was granted
whether you granted a rapist belong a status or not?
You keep using the word the rapist, and I have to see the person as a human being who probably made a mistake.
Rape is an act of violence, isn't it?
I agree, but still at the same time we have to show our human side. And this is a very specific situation. I think you said that the parents, I guess in their devastation, went to the premier and asked for mercy to assist them to at least. And again, I don't recall if in the end he actually got his status. I really don't recall. Honestly, I don't recall. Maybe he did. Maybe after the 3 weeks of the deferral, investigations were carried out and it was decided maybe it's not a good thing to do. The record will have to show what happened. I do not know. I can't remember.
A fair point, but it's just going back to the process, and just that where you have people who are firstly cannot be said to be of good character, and secondly cannot be said to be ordinarily resident if they're serving a prison sentence elsewhere.
Again, I don't know how long he was out of the country. I do not know.
But the point is, you just take it back to the process. If you can help the commissioner with this, how did cabinet approach those questions when considering how it was to apply its discretion under the law?
Again, somebody would have to flag it. We go through these things. Each member would go through. I would know some. Somebody would know some. And if anything is flagged, you may have heard something or seen something or know something. That's where it's flagged. Or from the document submitted. I think this was brought to our attention when the document came in. It said this person is charged. That's how we would have known. The AG would have known, and brought it to say, "Look, I'm concerned about this here. I am concerned about this." We look at it. Each person will bring their concerns, and maybe other concerns for other process brought by other ministers too.
But it's just taking you back to the law.
I get that.
I mean, forget about the two individuals, but it's just that where you have someone who has committed a serious crime, not speeding or something like that. But taking you back to the law as you were applying it in 2019, what was the basis on which cabinet considered you could grant that kind of status?
I can't say I know what the conversation was between the parents and the premier, but it must have been based on that discussion, whatever that discussion was.
But did you and the cabinet consider the conditions that still applied under subsection 4?
Absolutely.
Well, in terms of condition C, ordinarily resident for the period of not less than 7 years immediately prior to the application. This was a fast track application.
Yeah, but I'm saying I don't know how long a person out of the territory. It doesn't say how long he was out of the territory.
But this was a fast track application, so it couldn't have been made until the 3rd of June 2019. So I just don't understand how this individual could have been ordinarily resident for not less than 7 years immediately prior to the application.
I don't know the circumstances of the gentleman out of the country. That I don't know. I said maybe during the deferral period, that's what was investigated and further details. And whatever was reported back, at that point, we would have made a decision to either grant or not grant. But I can't say that it was done.
Part of the process, part of the, and we saw that in the policy paper, was that if you were applying under the fast track program, you would have to sit a written exam. And Mr. Penn's evidence was that applicants would have to actually come into the immigration department and sit that exam. I mean, you've got a situation if someone is outside the jurisdiction, because and not in the BVI. Can you? How was it? Was there a system whereby if you were outside, you could still sit that written exam?
I don't know the specific case. Again,
I'm not talking about the specific.
I think the answer will have to be no. We want you to be here in person to do it.
I see.
See, this is strictly an anomaly, a very strange and unfortunate anomaly that this young man found himself in this situation where the parents, I guess, came to the premier to make representation. Is there anything you could do to help my son to at least spend his days in prison in the BVI?
Does that, you may not know the answer to this, so don't answer it if you don't know the answer. But does that mean that these two applications, but certainly the application of criminal 1 was considered outside the provisions of subsection 4 and subsection 5?
I would almost, I can't say for sure, but on the face of it, it would seem so. More from a humanitarian gesture towards the family than actually prescriptive law.
Okay.
So it would seem at the surface. I don't really know.
The fair answer is.
And again, moving it away from these individuals and these circumstances, but and you may not be able to answer this, but I take you back to the fact you were on the committee in 2004. But if you have belongership, you can sit, you can, as you say, own property, you can buy property, you're free from immigration control,
you can vote.
And you can vote. Can you still vote if you're serving a prison sentence?
I think they made an amendment in 2015 where prisoners can vote for the first time. I think so, but ordinarily prisoners aren't allowed to vote. It might have been amended. I'll have to double check that, but I don't think prisoners are allowed to vote.
Commissioner, I think I've reached the conclusion of my questions, and can I conclude firstly by thanking Honourable Wheatley for coming this afternoon. I know that we expected him at 2, and he expected to be here at 2, and we started a little later than that, and I thank him for his patience. Can I also thank him for the way that he has given his evidence once again to the Commission? Yes,
can I echo that, Minister? Thank you for your time, which is, I know is valuable, and thank you for the helpful and frank way in which you've given your evidence. It's much appreciated. My pleasure.
We're not sitting tomorrow, but we resume on Thursday with.
Thank you very much.
Thank you.